Good morning. If everyone wouldn't mind, please rise and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Just a few housekeeping items before we begin. We have a lot of people here today. If there's not a chair in the room, I'm going to have to ask you to wait in the hallway until there is one. There's no standing, hovering around in the room. And if we have a lot of folks to testify, and I want to give everyone a chance to testify. That being said, we have a lot of bills. So if you hear someone testify and they're saying exactly what you were going to say, it would be great if you came up and say, I identify with the comments of that speaker, and we move right along. But if we hear the same thing over and over, we get the message and we appreciate it. We just want to make sure that everyone has a chance to testify. I'm not going to limit testimony right now, but if it looks like we're going to get too far behind, I may have to put a limit on time for testimony. So the quicker you are and get right to your point, the better your co-citizens will have a chance to talk. And with that, I will open the public hearing on House Bill 1730 and invite the sponsor to introduce the bill.
Thank you, Chairman Roy. Thank you, members of the House Criminal Justice Committee, for hearing my testimony today as I introduce House Bill 1730, an act making all offenses against minors involving sexual penetration or contact felony level offenses punishable by death. I know this is a heavy subject. I know this is a topic that you spent hours on yesterday already hearing other bills dealing with the death penalty. We filed this bill specifically for those crimes committed against children that are just so heinous and unbelievable for a just society to live with. I think of the types of crimes in which rehabilitation works, in which sending somebody to prison, sending them to jail, sending them to counseling, rehab, to get them back on their feet, back into becoming a productive member of society. And then I think of these crimes, and these crimes are not that. I firmly do not believe that somebody can commit a crime against a child in the manners defined in this bill and be rehabilitated back into society, which leaves two options: either life in prison for the offender, or for the ability for a jury and a judge and a jury of their peers and a judge to sentence that criminal to death once they are found guilty of the crime. Obviously, that's a big jump from what we are currently doing. When I reached out to OLS to start drafting this legislation, one of the responses back were some of these crimes aren't even felonies in the state of New Hampshire today. They're just listed as misdemeanors. So if there's anything that comes out of this bill, examining that might be the way going forward. But firmly, I believe, and even as a Catholic who believes that every life is sacred, the crimes that are being committed here ruin the lives of the victims and the survivors to an extent where we can't live in a society with those that perpetrate it, and I don't see a path for rehabilitation for making those individuals productive members of society again. I know it's a heated topic. I know we could go into philosophical debates for hours. I don't want to do that. I don't want to spend more of the committee's times doing that. I'm sure you'll have plenty of other speakers to speak on the various facets of this bill after me, and you'll have plenty of time during executive sessions to discuss the bill. So I will leave my introductory testimony at that as sort of the grand overview of why I filed it. I'm happy to take any questions from the committee. And I know you guys have spent a lot more time on this sort of policy than I have with this bill. So thank you.
Thank you for your testimony. Questions? Representative Scheer.
Thank you, Mr. Chair. Welcome, Representative Sweeney. Are you aware that the United States Supreme Court has ruled that the death penalty is unconstitutional when applied to conduct that did not result in the death of somebody or when the death of somebody was not intended? Are you aware of that?
I am aware of that, and I would argue that the death of the sexual contact and penetration of a child could lead to a death.
I think the point, I think
Yeah.
I got you.
I think we're just going to disagree.
Well, my question was, are you aware that it's been ruled unconstitutional by the Supreme Court? Whatever your belief is.
I'm aware of previous rulings that have ruled that.
Follow up.
Yeah.
Do you know how many felony sexual assaults of children under the age of 16 are people are convicted of that each year in New Hampshire?
I'm not.
And if I were to say that it's certainly well over 30, would you disagree with that?
I would not. I would have no basis to disagree with it. I think one is too many. So certainly over 30 is way too many.
And the fiscal note here is, I'm sorry.
Just go ahead.
Okay. The fiscal note here is $7.5 million. Is it your understanding that is per case?
That's not my understanding. I wasn't involved in the drafting of the fiscal note. And I think it would be wholly dependent on which cases get the death penalty and which don't.
I appreciate that. If a case is eligible, do you understand that if a case is eligible for the death penalty, whether the person gets the death penalty or not, the huge amount of cost is in the trying of the case?
Yes.
Okay. That's
Just, I have one more question.
okay.
And I think you're aware that does your opinion change about this bill if the bill that has passed the House that gave a life without parole sentence to anyone convicted of a sexual assault of somebody under the age of 13, does your opinion as to this bill change?
I don't think the opinion changes. And in my testimony, I stated that I think the individuals that commit these crimes should either get life without parole or they should get the death penalty. And this bill covers under the age of 16. So it's a bit of a wider scope there, but not totally disagreement on the wavelength there.
Okay.
Thank you.
Thank you. Any further questions? Seeing none, thank you for your testimony. And as a fellow Catholic, I look forward to seeing you at the confessional this Saturday.
Thank you. Yes.
The chair calls Representative Susan Elberger. Sir, on the left, could you grab that chair, sir? Could you grab the chair, please? I didn't want anyone standing, so if there's an open chair, please occupy it. Thank you.
Thank you, Mr. Chairman. Thank you, members of the committee. For the record, my name is Susan Elberger. I am honored to represent Hillsborough 5, which is Nashua Ward 1. To be honest, I've been torn about the death penalty for a long time. I know that there are people whose crimes are so heinous that it's possible that they could not be rehabilitated, but it came down to two decision points for me. One is that sentencing for the same crime is not equitable across race or economic divisions in the country. And as long as that's the situation, I can't support the death penalty. The other question that I had to ask myself was, would I be willing to be the one to inflict that death penalty? And the answer is no. If I'm not willing to do it, I don't think I should be asking anyone else to do it, and therefore I'm opposed to the bill. Thank you.
Thank you. Does anyone have a question? Seeing none, thank you for your testimony. The chair calls Representative David Fract. Could you see if David Fract is in the hall, Representative Fract?
Mr. Chair, I'm sorry, I was confused. I am not speaking on this bill.
Okay. Actually, we may be confused, so don't worry about it. Representative Rob, oh no, Dr. Rob Spencer.
Good morning. Thank you all for your service, your time, and your attention. My name is Dr. Rob Spencer, and I've practiced medicine in Concord since 1996. In 2013, I was asked by the governor to serve on a legislative commission to study end-of-life care here in New Hampshire. Also serving on the commission was a legislator who had consistently voted in opposition to abolishing the death penalty. He and I talked about the death penalty several times. One conversation was a chance meeting in front of the State House that happened to be on Good Friday. I asked him if he knew what day it was, and he said, "What do you mean?" And I said, "Well, today is the anniversary of a famous person being put to death who was later proved to be innocent." And he said, "Oh, was that one of the cases in Texas?" And I said, "No, today is Good Friday." We had subsequent conversations, and he was one of the many legislators who changed their view, originally voting to maintain the death penalty, but ultimately voting to abolish it. At the end of life, people often reflect on how their views have changed over time. Legislators are not the only ones who've had a change of heart regarding the death penalty. Correctional officers who've participated in executions may be haunted by the role they once played. If you are considering a vote to return the death penalty to New Hampshire, I invite you to pause for just a moment, take a deep breath in for inspiration, then let it out with the knowledge that the time will come for each of us to expire. Consider the possibility that, like many others before you, your views may change. Then do your future self a favor and let the death penalty in New Hampshire rest in peace.
Thank you for your testimony, Doctor. Anyone have any questions? Seeing none, thank you. The chair calls Reverend Harmon.
Thank you very much. Greetings. Good morning, honorable representatives. Thank you for your time and your service this morning. My name is the Reverend Zachary Harmon. I serve St. Christopher's Episcopal Church in Hampstead. I'm a resident in Goffstown, New Hampshire. And I am here today to testify against the reinstitution of the death penalty, and specifically as it's proposed in 1730. As a faith leader, I believe the death penalty goes against core Judeo-Christian principles. The Ten Commandments state, "Thou shalt not kill." When confronted with the death penalty, Jesus Christ himself said, "Let the one who is without sin throw the first stone." In Genesis, in the Bible, we hear that all people are made in God's image, that each person has intrinsic worth and value. And following that, in Genesis, when God punishes Cain, the first murderer, God does not give him the death penalty. So I hope we will not turn New Hampshire into an institution that acts against these fundamental values. The death penalty is irreversible, and I believe you'll hear more testimony on that, so I'll just leave that. The death penalty also tears the fabric of our societies, our towns, our families apart. Every person is someone's son, daughter, mother, father, brother, cousin, friend. And I worked, before I was ordained as a priest, I worked as a juvenile court clerk for 3 years. And very often there saw that offenders in these kinds of cases were part of someone's family or close friend. And how do we want to traumatize these families more? The death penalty also makes death and violence part of the state apparatus. It normalizes violence in our society. How can we be in favor of such a thing? And furthermore, sometimes there is this sense or idea that the death penalty is, or some kind of bloody revenge has been a part of our human makeup since the dawn of time. But that's not true. If we go back 2,500 years to Athens, Aeschylus wrote the Oresteia. It's this Greek drama that shows that bloody revenge should not rule the day, but justice in a holistic society, that's what we should be about. And likewise, in the ancient Irish legal code of the Brehons, which lasted until the 1500s, little room was made for the death penalty, and it was viewed largely as a failure of justice, as it contributed so little to society, in contrast to other forms of justice that sought to restore and compensate the victims. Honorable representatives, I urge you to uphold a good and ordered society in New Hampshire, and to keep the recklessness of the death penalty out of our beloved state. Thank you for your time.
Thank you for your testimony. Seeing no questions. The chair recognizes Marnia Page.
Good morning. My name is Marnia Cushing Page, and I live in Exeter. I come before you to voice my strong opposition to all the death penalty bills before you, and especially one that cuts deep into my heart and soul, House Bill 1749, which allows the death penalty for capital murder, first-degree murder, and second-degree murder. My father, Robert Cushing Sr., was murdered on June 1st, 1988, in the home I grew up in, along with my 6 siblings. Around 10 o'clock in the evening, my father answered a knock on the door. As he opened the door, gunshots ripped through his body. His blood and guts painted the floor and walls. My mother watched in horror as the love of her life was killed. My family's world changed forever on June 1st, 1988. How did we possibly survive the trauma and turmoil to follow? The violent death of my father changed my normal reactions and responses to daily life. My father's killers were found, Robert McLaughlin Sr. and his wife, Susan Sam McLaughlin. Our family sat through 2 murder trials. Robert McLaughlin was found guilty of first-degree murder, and Susan McLaughlin was found guilty as an accomplice to first-degree murder. Both were sentenced to life in prison without the possibility of parole. I was satisfied with their sentences. I subconsciously became opposed to the death penalty on the first day of the trial of Robert McLaughlin Sr. I arrived at the courthouse with my mother and my brother Rennie. We stepped into the elevator along with a young man. Rennie introduced him to us. He was Robert Bobby McLaughlin Jr., the son of my father's killer. Bobby looked at my mother and said, "Mrs. Cushing, I am so sorry for what my father did to your husband." In that instance, I realized that he too had lost a father on June 1st, 1988. I realized that he too was a victim of a murderous act. The life sentences given to my father's killers cannot coexist or be compatible with the death penalty. The death penalty does not meet or satisfy my need for closure and healing. It will never bring my father back. My grief will continue. There will be triggers that cause me to be hypervigilant and feel emotionally numbed and easily frightened. Why does this happen to me? It's because of the brutal, savage, and cruel murder of my father. Let us not sugarcoat the meaning of the death penalty. It is murder, period. It is the state-sanctioned killing of a person. And perhaps, just perhaps, that person, that murderer, has loved ones. Innocent loved ones, spouses, children, siblings, parents, aunts, uncles, friends, and a community. They will become victims of the state murder, and they will suffer too. Let us stop this killing and all the killings. I respectfully ask that you do not reinstate any of the death penalties in New Hampshire, and I thank you for your consideration.
Thank you very much for your testimony. Will you take a question, ma'am? Oh, okay, never mind.
A procedural matter.
Yeah.
I said this yesterday as to the death penalty bill we started to hear yesterday, but could I ask that all the testimony we hear on all the death penalty bills in front of us be attributed to each of the bills?
And to the extent that they equate legally, in other words, if there's a legal difference between what it's for, et cetera, otherwise, yes. That's why I didn't interrupt Mrs. Cushing, because I don't think she mentioned the bill that we're talking about.
I understand that.
Yeah,
I just want to make
okay.
that clear. Thank you.
Yes. Yes, sir.
Thank you for taking my question. And let me say that I served with your brother. And one of the things that has always bothered me about life imprisonment is the family, when the imprisoned person comes and makes appeals, and in some cases is let out of prison. Did you go through that with this person? And what did you feel as a family member of the victim when these appeals came up?
Well, when different appeals came up, it does trigger like the events of June 1st. However, I would always say to myself, well, I can't really blame that person for trying to like get out. But I still would not, I still would rather go through that than knowing that I supported that person being killed.
If I may, the sentence they received was life. Was it? I thought you said without parole.
Yes, life in prison without the possibility of parole.
So, but they still had parole, or were you saying
No,
that-
without.
No. You said you had to deal with parole hearings,
Oh.
or was it appeal hearings you were talking about?
Oh, no, I'm sorry. It was for, to be pardoned.
Oh,
They would-
okay.
Yes.
Yeah, those we can't stop.
Yeah, yeah.
Thank
yes,
you.
I'm sorry.
Okay, thank you for your testimony
Yeah.
this morning. The chair calls Dr. Feder.
Hello, members of the committee. Thank you for hearing my testimony. I'm a psychiatrist in Concord, speaking for myself, not for any organization you may associate me with. And I've worked in the secure housing unit at the New Hampshire State Prison for Men and talked with a lot of individuals who have committed murder or been convicted of murder. First, I want to say that I think that as a policy matter, the amount of money that gets spent to go through with the death penalty case is money I would rather go to the correctional officers that I worked with. Once you've had someone in a blue uniform step between you and someone who wants to do you harm, you really appreciate what it means to have that courage and that role and that training. And I've seen people working double shifts, being forced to work, and I would rather have that money support them so they can do their jobs properly and feel supported in that role. I've spoken with dozens of people who have been convicted of murder under HIPAA protection after they've been convicted for life without the possibility of parole. And they come to me for help as a psychiatrist. So they're telling me pretty much what they think about what happened and what they think about what happened and where they are now. And I'll tell you that talking with these folks, they're not necessarily the people I expected to be talking with when I started in that role. I have spoken with serial killers who have raped and murdered people all across the country, and we don't know where they all are, and they're figuring out whether they want to tell people. I've talked with a young man with dead eyes who ended up somehow in the theater program in the prison. And after a few years of doing this, was a whole different person than what I knew. And he'll be in there for the rest of his life, but he'll become what I've also seen, which is the older lifers who are kind of a role model to the other younger folks and saying, like, don't be like me, do something different with life. I've seen people who have killed people while on meth and are tortured and guilty about what they've done, and to be given the death penalty would be a release and a relief to them. I've seen kids who were just followers and really, really didn't understand where things were going until they were out of control. I've seen people who are so psychotic, I don't understand why they're not guilty by reason of insanity. But I'm not the judge. But it's you guys' job to determine what the judge has the power to do. And I have a reasonable doubt whether a judge can be wise enough to apply the death penalty where any reasonable person would look at it from a God's eye view and know all the facts and really understand this is a person who deserves to die. I have a reasonable doubt that anyone should have that power, and I think you should too. Finally, this specific bill is about sexual offenses against children. And I will share with you that that kind of thing has happened in my extended family. And the ramifications of those acts have caused mental illness, chaos, conflict, poverty that affects people I love. And I would not want that person killed. That would just be another tragedy in my family. Thank you for listening.
Thank you for your testimony, Doctor, and thank you for your service to the state. The chair recognizes Devin Chafee.
Good morning, Chairman Roy, other honorable members of the committee. For the record, my name is Devin Chafee, and I am the Executive Director of the ACLU of New Hampshire. And I'm here to testify this morning in opposition to House Bill 1730, as well as all other bills that seek to reinstate the death penalty. And I want to start by really recognizing that opposing these bills does not diminish the seriousness of violent crimes or the targeting of children or the harm that is suffered by victims. Because the question before us today is not whether such acts deserve condemnation. Of course they do. We know that they do. But the question is whether or not reinstating the death penalty is going to make us safer or if it's going to make us more just. And the evidence simply shows that it is not. Instead, the death penalty is inherently contrary to the constitutional protections against cruel and unusual punishment and the guarantee of due process and equal protection under the law. And it is also ineffective and, in fact, oftentimes counterproductive, harming those that it is supposed to protect. And if we're going to talk about reinstating the death penalty in New Hampshire, I think it's really important that we look the horror and cruelty in the face of what it means to execute an individual. Because under New Hampshire law, we have two options, hanging and lethal injection. And both of these forms of execution are known to lead to protracted and painful and sometimes gruesome deaths. It's also important to remember that the death penalty is frighteningly arbitrary in how it is applied. The 14th Amendment guarantees of equal protection are routinely violated in capital sentencing, and we know from decades of research that what really determines whether or not someone is sentenced to death is where they live, their race, and how much money is in their bank account. And this is for a punishment that cannot be reversed. No criminal sanction is more final than execution, and no system more prone to irreversible error. And yet the death penalty doesn't make us safer. And in fact, HB 1730 in particular puts victims at greater risk. Empirical research is very clear that the death penalty does not deter crime. And in fact, you see that states that do not have the death penalty have lower murder rates than states that do. But what is particularly concerning in the context of HB 1730 is that experts warn that death-eligible penalties reduce reporting when related to abuse occurring within families. And as we heard from a previous speaker, the tragic reality is that the type of abuse that is highlighted in HB 1730, targeting children, often occurs within families. Essentially, what happens in family members are less likely to report instances of abuse if they are afraid that they may be sentencing their own family member to death. And what this does is put children who are already in horrible, vulnerable situations and makes them even more vulnerable. And this is not to mention the victim's pain and re-traumatization that is caused by the very prolonged and lengthy appeals process required for death penalty trials. And this speaks to the representative's earlier question that the appeals process for death penalty cases is much more extensive than what you would experience in a trial in a trial where death is not on the line because of the constitutional protections that Representative Scher highlighted earlier. And I just want to leave you with this. Over the years, and I've been working on this issue for over a decade in the state of New Hampshire, I have seen a lot of members of this body, a lot of legislators change their mind on the death penalty. And some folks have been persuaded by the stories of death row exonerees that they have heard. Others just feel that the government can't be trusted to put a person to death. And others were persuaded by their conversations with Representative Cushing. And I know you are going to hear from have already heard from some of his family members, his sister, and will hear from his daughter later today. One of the strongest opponents of the death penalty that I have ever met. And I so wish he could be with us here today. And while I have known dozens of legislators who have gone from supporting the death penalty to opposing it, I know very few, if any, who have gone the other way. And the thing about the death penalty is that it is final. It is irreversible. And so what I would respectfully ask, if you are considering possibly supporting one of these bills, are you absolutely, completely sure? Is there any inkling of doubt in your mind that this penalty might not always be used fairly and humanely and without mistakes? Because if there is any doubt, if you have any question, then I would respectfully suggest that the answer is clear. And I would respectfully suggest that you vote inexpedient to legislate on HB 1730 and all related bills that would reinstate the death penalty. Thank you so much for your time.
Thank you. If I may ask just a quick question.
Of course.
Something you said triggered something in my mind. You said that someone may not come forward because they would be, in a sense, themselves sentencing their abuser to death. Does it also make it perhaps more likely that that victim might themselves be killed so that they're not a witness available to testify?
Absolutely, Representative Roy. And, and experts, folks that work with victims of violence have, I know, and we can provide more information on that. Absolutely, Representative Roy. It actually makes a victim more vulnerable that they may, in fact, be killed because, the perpetrator is concerned that death might be a result.
If you have those kind of statistics available, I'd be interested in having them emailed to the committee.
Absolutely. Absolutely, Chairman Roy. I will follow up with that information.
Thank you very much.
Thank you.
Representative Scher.
very briefly, are you aware of a study out of, I believe, the University of Michigan that using statistics over the last 30 years, finding that it's very likely that 4.1% of people on death row are innocent?
Representative Scher, I was not aware of that particular study. I do know that there were over 190 people nationwide that have been exonerated from death row since 1973, but that's that we'll make sure that the committee gets that study as well. Thank you.
Thank you again.
Thank you.
The chair calls Louise Hayes Snow.
Good morning, committee. Thank you for hearing from all of us. My name is Louise Hayes Snow, but I go by Brecky. That's what everybody knows me as. And I'm here as a person whose family has been touched by violent crime. In 1981, my mother's ex-husband murdered her fiance in our driveway. Obviously, our entire family was rocked. My sister was only 11. The whole family was devastated. We suffered the trauma, not to mention the grief of that action. Most of us were home at the time, so we all heard the gunshots. He was caught almost immediately. He was tried and he was convicted of murder. He received a life sentence. During the process, we were all interviewed. My mother testified during the trial. My recollection is that it took forever, but I think it was maybe a year before he was convicted, maybe a little more, really not that long in the great scheme of things. What I remember most when we heard that he had been convicted was the incredible sense of relief that we all felt, that it was over, it was behind us, the system had done its job. And that's my greatest memory of that entire experience. My mother always opposed the death penalty, even during the time when she was testifying, even though she had been the witness to the murder. She is not here today because last May she was killed by a drunk driver. It was the day before her 88th birthday. So we'll always remember when that happened. We shared our views on the death penalty. We both believe that the criminal justice system is not here to exact retribution, and that death is no deterrent to crime. Death was a punishment for various crimes for hundreds and hundreds of years, and it doesn't seem to have done anything to deter crime. When Ray Barham was convicted, he appealed one time, and there was no testimony involved. It was a matter of law, question of law, and that was the end of it. The case was closed. Had he been sentenced to death, how many hearings would there have been? How long would that appeal process have gone on? How involved would my mother have had to have been in that ongoing issue? When would we have had the peace of finality? And now I know that the person responsible for my mother's death does not face any charges that would hold the death penalty. And for that, I'm grateful, because our participation in the criminal justice system is not going to make us complicit in the taking of any additional lives. It's not going to interfere with our ability to move forward and find the peace and manage our own grief. Our outrage doesn't entitle us as a community to kill. And it doesn't matter whether we're talking about House Bill 1749 or 1730. The bottom line is that our community should not be seeking to kill on behalf of anybody. So I would urge you not to make victims or survivors of crime complicit in the taking of additional lives. Thank you.
Thank you for sharing with us this morning. Representative Scher.
Just a comment. It's good to see you again, Brecky. Brecky is also a former student of mine.
Okay, I'm going to have to put some kind of ban in effect on that because we have to, we get 4 a day. Thank
It was
you
a
very
long
much.
time ago.
Thank you. Oh, yes. Tell us how long ago was it?
I would ask that the chairs might
Yeah.
be muted.
Thank you.
The chair recognizes Christine Rockefeller.
Good morning. Thank you very much for your service. I know sometimes you may think that it's a thankless job, but I can assure you it's not. And
We are
appreciate-
handsomely paid.
And we know you're not in it for the money. My name is Christine Cushing Rockefeller. You can connect the dots. I'm Marnia's sister and Rennie's sister, so I'm not going to repeat all of the facts, but I do want to add some things to it and share with you my reasons for opposing all of these bills. And since she spoke so eloquently, I'm just going to go off script a little bit. I practiced civil law for 35 years in Dover, and the reason I say that is when I got the call that night and went to the hospital, and first person I saw was a priest coming out, so I knew my father was dead. I knew what we were in for in terms of the judicial process, appeals, and the toll it takes on the family. I can tell you that one thing my sister did not mention is that we are, our family was a victim of another murder 23 years after my father was killed. My brother-in-law of 30 years was brutally murdered, and in a cruel twist of fate, he was gunned down on his front door just as my father was, with my brother Matthew, his husband, feet away, watching as well. Mercifully for Matthew and the families, Stephen's killer, his nephew, took his own life, so the judicial system was not involved, and for that, we were spared additional re-trauma. But I want to speak to you because it struck me as I was signing in that you're the criminal justice and public safety committee. So I want to talk to those two issues. As a survivor, and to speak to both of your issues, we are re-traumatized all the time by little things that I won't even bother mentioning. But in order for us to try to heal and move on, we needed some closure. And I feel that as a lifelong New Hampshire resident, justice was served. The killers are in jail for life without the possibility of parole. Yes, we had to endure initial appeals and we've had to endure pardon hearings, but I feel like justice has been served, and I feel like I'm safe, and I feel like the citizens are safe because I continue to have faith that our system is not broken. So please ask yourselves, what problem are you trying to fix? Because I'm not seeing a problem. And unfortunately, there are so many of us here in the room today speaking in opposition, and we're victims. And so I would ask yourself, if you think you're doing this in the name of the victims, you're not. We don't want this. I do not want to be turned into a Robert McLaughlin and a Susan Cook. Please do not put their blood on my hands, because that is going to really send the survivors over the edge and not allow us to recover. So please ask yourself, I still don't understand what the problem is that this committee is trying to fix. And I say that respectfully. I know you have a difficult job to do, But I think that when so many of us as victims come talk to you and express our positions, I think our voices should carry weight, and I think all victims' voices should carry weight. And if there are victims here, not people who are speaking in the hypothetical, what if, we've lived it. So if there are people here who have lived it and are in support of the bill, I respect that. But where are they? And so I would ask you to give our voices very serious consideration before you undertake your deliberations on this. And finally, speaking to Brecky's point, my mom moved in with my husband and my family after my father's death. And so my daughters, our daughters were raised with my mother's constant nightmares, the same nightmare and the same screaming, until she died 2 months before her 95th birthday. So my daughters grew up without their grandfather, and they grew up knowing of their grandmother's nightmares. But she remained opposed to the death penalty until the day she died. And she went to those appellate hearings, and she went to those pardon hearings. And the death penalty isn't going to bring anybody back. So please vote against these bills. Thank you.
Thank you for sharing with us today. What we got? Yes. Go ahead.
So just so you know, you have some on this side. My brother-in-law was shot to death. So I've been there. So thank you for your testimony.
Very sorry for your loss.
The chair recognizes Richard Dieter.
Mr. Chairman, members of the committee, thank you for this opportunity to speak about the costs of the death penalty, especially as they may relate to New Hampshire. My name is Richard Dieter. I am an attorney and reside in West Virginia. Relevant to the testimony I'm going to give, I would point out that I was the executive director of the Death Penalty Information Center for 23 years. Also was an adjunct professor of law at the Catholic University Law School for 14 years. So in that employment, I studied the issue of capital punishment, and when it comes to the costs, prepared reports, chapters of books, read all the studies I could find on the cost of the death penalty, and that is what I want to share today. It's a complex issue. I brought a copy of a longer testimony with which I could leave with the committee with your permission. I will summarize my remarks and try to keep them within a reasonable amount of time. I think that there's the danger that in issues of life and death that we're talking about here, one might think that costs are not important, or at least are of minor importance. But I would disagree with that because, one, we're not talking about a minor amount of money. The experience in other states is that we're talking about millions of dollars that will be needed. And over years, it's hundreds of millions of dollars. Second reason is that I know as legislators, you recognize that a program like this is not funded out of a vacuum. It comes at the expense of other programs. You have to choose. We, the people, have to choose. There are programs that help reduce crime, and there are mental health procedures that may, specifically address crimes such as the bill that before you are talking about. But all of those things have costs, and so it's a choice, and you should know, how much the death penalty costs. And I can tell you that of the studies that have been done, the comprehensive studies In many states, all consistently come to the fact that a system with capital punishment is going to be a lot more costly than a system where the most severe punishment is life without parole. Just to give you an example of some of the states, the best study I think was done in Maryland by the Urban Institute, and found that over a 21-year period, the state of Maryland spent $186 million. During that time, they had 5 executions, so the cost per execution was $37 million. It's not to say that one execution costs that money. What we're talking about is a system. A system means that the costs of the death penalty begin at the moment a case is identified as a capital case. 2 lawyers are appointed. 2 prosecutors probably are going to be involved in this. Mitigation evidence has to be investigated all throughout a person's life. And it goes on and on through trials, appeals. Every step of a capital case is more expensive than a non-capital case because of what's at stake and because of the limitations the Supreme Court has put on this. New York, for example, had an experience or experiment, if you will, with the death penalty. They had it for 9 years over in the 1990s and spent $170 million by a cost study.
Sir, just, I don't want to interrupt, but I'm not sure if you're aware, but until relatively recently, we had the death penalty. So we're pretty aware of its expense.
Yes. Well, you know, I am aware and have been appeared before this or similar committees in New Hampshire in the past. But, you know, just to put some factual numbers on this, I mean, what New York discovered was that expense was not worth it, and they abolished the death penalty. New Jersey spent had a death penalty for 25 years and spent $253 million and no executions and abolished the death penalty. In Virginia, they had no death sentences. They had almost no death sentences for 10 years and abolished the death penalty. So Connecticut, a similar pattern. And you might think that, well, there's some savings in the death penalty because people might be pushed to confess or to take a plea bargain, and that would save money. That is not the case. The federal government studied this issue and found that cases that resulted in a plea bargain cost them about almost $200,000, even when the death penalty was not imposed. Whereas cases where the death penalty was not sought were only costing the federal government $55,000. So it's a lot more just to seek the death penalty than having a plea bargain. As soon as the case is, as I say, initiated as a capital case, the clock starts ticking, the money starts pouring in. More lawyers will be needed, more experts will be employed, more questions will be asked of potential jurors, more time will be taken for a 2-part trial and dual appeals. There's not just a question of guilt, there's a question of sentencing, and each of those requires that. And that's why you see these high numbers. In some cases, the cost might be viewed as what we call opportunity costs, that you know, the federal not the federal, the state prosecutors are paid on a salaried basis. So might the public defender. So, you know, more work doesn't mean more expenses. But that's a rigid way of looking at it. Those are opportunity costs. Those lawyers, prosecutors, defense, judges, they're going to be spending maybe 1,000 hours on a death penalty case, whereas they would spend 100 hours if it were a non-capital case. And so that's an expense. It may not come up in the budget as that, but you're losing the time for solving other cases, completing other cases, et cetera, when you put in the death penalty. The other issue that affects costs is this issue of innocence, and some people have raised this prospect. The death penalty was, you know, increasing for a long time in this country, but as more executions occurred, more cases were found where there was new evidence or the evidence was not properly presented earlier, and people were freed. And this is still happening today. This innocence issue has slowed the whole process down. So we have gone from a country that in the 1990s there were 300 executions, 300 death sentences a year, and close to 100 executions in a year. Now we are down to about 25 death sentences in a year from 300. Executions have dropped considerably, about 75%. 11 states have voted to abolish the death penalty. Public support in the polls has dropped from 80% support in the 1990s to 52% support in the present era. So there's a movement away from the death penalty, and that has meant that the cases are spread out more, less frequent, and that raises the costs per case, per individual. So to bring this to focus, I mentioned one example in the state of Georgia where they spent $2 million on the case of Brian Nichols, and it resulted in a verdict of life. But that money that was spent had drawn down the budget for public defense, and so they started cutting the money and cutting the public defender's office. Public defender quit. The state public defender quit because they couldn't adequately defend cases. The decisions about the death penalty have effects throughout the system. And that's why you heard from one police chief in New Jersey when they were considering whether to keep the death penalty. And he said, "I have learned that the death penalty throws millions of dollars down the drain, money that I could be putting directly to work fighting crime every day, while dragging victim families through a long and tortuous process that only exacerbates their pain. As a police chief, I find this use of state resources offensive. Give a law enforcement professional like me that $250 million and I'll show you how to reduce crime. The death penalty isn't anywhere on my list." So in summary, when considering the death penalty, you're looking at a broken system, a system that states are moving away from. And expense is part of it. It's not one number that you can assign to the death penalty, but you can be sure that the costs will be extensive and that they will start as soon as a law is passed and the case is potentially going to be death penalty. The judge has got to be appointing people who are experts in it. The judges have to themselves educate them. There'll be appeals. There'll be many years before anything happens. We're now at a point, according to the Federal Bureau of Justice statistics, where it's the longest time in the recent history of the death penalty from sentencing to execution. In the latest numbers, it was 23 years to go from sentencing to a final execution. And of the people who were sentenced to death, only 17% actually resulted in an execution. So we're looking at a system that is highly inefficient, broken in many ways, being abolished by many states, and that is the current status of the death penalty in the United States, and should be of consideration when if you're going to reinstate the death penalty in New Hampshire. I'd be happy to answer any questions which the committee may have. As I said, I have written testimony for more facts and figures about some of these death penalty studies. Thank you.
Thank you. If you don't mind passing your information down to the Representative Scheer over here, he'll make sure that we get it. And thank you for traveling to testify today.
No problem. Thank you.
There's no question, Jerry.
Thank you.
The Venerable Jeffrey Smith, assuming that's what Ven means.
Actually, it just means old.
I think, can I start using that?
Good morning. My name is Jeffrey Smith. I serve as the Archdeacon, which is where the term venerable comes from, of the Episcopal Church in New Hampshire. And I thank you all for giving me the opportunity to speak in opposition specifically to House Bill 1730. The Episcopal Church has long opposed the death penalty for the strong reasons already mentioned by Reverend Harmon and yesterday by Bishop Rob Hirschfeld, my boss. And so I'm not going to repeat those rationales and strong reasons. But in the context of House Bill 1730, it's a call to expand the death penalty to all offenses against minors involving sexual violence, and that's abhorrent. While I can understand society's outrage at these crimes and share them myself, particularly with the revelations of the Epstein files that are coming to light, as a survivor of child sexual abuse myself, I am deeply troubled by the idea that killing the perpetrator will give a sense of closure or satisfaction to the victims or their families. I can tell you from personal experience, it will not. No child should have to deal with the knowledge of being associated with the death of another human being. The trauma of child sexual abuse requires both psychological and spiritual healing, the costs of which would be much better served with the aid of the state, rather than those funds, as Representative Scher has pointed out already, being spent on legal appeals. Our church, the Episcopal Church, is grounded in the faith of a merciful God for all, but especially for society's most vulnerable, our children. I implore you that reinstating and indeed expanding the death penalty in the way proposed by this bill is morally repugnant and means accomplishing nothing for justice. Thank you.
Thank you for testifying. If I'm not mistaken, there was also something he mentioned about God, about justice. I mean, vengeance. I think something about he owns it, I think, if I'm not mistaken. Next. No questions.
Thank
you. The chair recognizes Elizabeth Cushing.
Thank you, committee, for listening, for hearing all of these amazing speakers. I want to thank each person here in opposition of these bills. There was some amazing organization work which took place to get these speakers here, and I hope that the committee can appreciate that effort. My name is Elizabeth Cushing. I live in Hampton. I work in Dover in the criminal defense field. I have spoken before the legislature on this issue before. As my Aunt Christine Rockefeller put it best in her previous testimony, I was here before, and I'm here again now. I will add, I will be here in the future as well. I am the middle daughter of Rennie Cushing, who I believe does not need introduction to this committee. I am also the granddaughter of Robert Cushing Sr., who was murdered in 1988, 4 years before I was born. I am the niece of Stephen McRedmond, who was murdered in 2011. I was raised in a family inextricably connected to grief, and then experienced firsthand the loss of a loved one to murder in my late teens. The situation of having a family member murdered is not an intellectual exercise for me. Robert McLaughlin is still in prison for shooting my grandfather in the front doorway of the home my family built and my father grew up in. Brendan McRedmond, my uncle's nephew, killed himself after shooting my uncle Stephen on the front porch of his home. I'm no more comforted by Brendan's death than I am by McLaughlin's life in prison. I live in the house where my grandfather was murdered. My uncle Matthew lives in the house where his husband and partner of over 30 years was murdered. We are not allowing these acts to closely define how we live our lives, much like we will not let these acts strip us of our humanity. The death penalty is morally bankrupt and provides no comfort to this family. I do not want the state to take the lives of others in the names of quote-unquote justice for my family. One death is enough, and I wish to see no other families have to go through what mine has. As my dad often liked to say, Governor William Badger first stood in front of the legislature in the 1830s and advocated for the abolition of capital punishment. Almost 200 years later, in 2019, this body of legislature voted to abolish the death penalty. I was lucky enough to be present during the final vote to see the hard work of decades of advocacy and organization finally pay off. I had hoped these 2 months would remain as the first time the legislature addressed on capital punishment and the last time that it addressed it, but here we are. In preparing for this testimony, I have thought a lot about my dad. I wish he was here to be able to deliver a speech with all the right words, with the wisdom that unfortunately came with over 34 years of grief over the violent death of his father. I'd like to think he would have the magic words to convince you all of the reasons why New Hampshire can live without the death penalty. But I'm also ashamed and deeply saddened that we are still having this conversation. My dad fought for decades to abolish the death penalty in New Hampshire. It was one of his proudest accomplishments. I urge you to remember his leadership, to remember his dedication to the cause, and to remember his words. If we let murderers turn us to murder, we give them too much power. They succeed in bringing us to their way of thinking and acting, and we become what we say we abhor. I'm asking this committee to make a choice, to choose to be on the right side of history, to align yourselves with these amazing speakers that we've had so far, with Governor Badger and with my dad, and to vote no on all these death penalty bills. Thank you very much.
Thank you very much for sharing with us today. The chair recognizes Rashani Reese.
Good morning, Chair. Good morning, esteemed members of the committee. This is a very large chair. Okay. It's so big. My name is Dr. Brashani Reese. I'm the Executive Director of Drop Life Without Parole New England. I hold the doctorate in forensic psychology, and I'm a certified restorative justice facilitator, a practice that I came to as a survivor of attempted murder. It's good to see all your faces again. I had the pleasure of speaking with you all last year, and it's good to be back in the great state of New Hampshire, though I am here to oppose the bill that we are hearing this morning, HB 1730, and all related death penalty bills. You have my written testimony in your hands, so I actually want to focus my comments instead on the comments that were made last night by the sponsor who introduced this bill, the bill from last night. Yesterday, we started to hear some graphic details of heinous murders and horrible sexual assaults. And those are heartbreaking stories. And as a survivor who almost lost her life at the hands of a violent person, it was deeply painful to hear. But I'm going to ask, please, do not be fooled. Do not allow the graphic details of really horrible incidents to lure you into the idea that the decision around whether or not we should kill someone should be made out of emotions. We should not build broad state policy on the foundation of personal pain. I hear a lot of amazing survivors in this space directly related to New Hampshire. I have a lot of respect for them and deep admiration. But in hearings like this all over the country, we talk a lot about survivors of violence. But we're not talking about what there's not in the system for us, because I have to tell you, there's very little in the system for us. We offer the death penalty in some states. We offer life without parole in all states. And a survivor-centered system is not one that only offers those things. I could actually give you a list of the things that would have been helpful when I was going through what I was going through. And I think all survivors could. I don't hear us talking about that, though. Instead, last night I heard about humane firing squads and cost-effective executions. There is nothing humane in repeating the cycle of violence. I'm going to ask the chair if it's okay. I'd like to submit a copy of a report that was done specifically about survivors. It's all over the country. And it talks about what survivors of violent crime actually need. And so I asked the state of New Hampshire, please, let's focus on crime prevention
Thank you.
and rehabilitation. Thank you so much for your time. I urge you to vote ITL on all of these bills.
And thank you for taking the treacherous drive up from Massachusetts.
A long hour.
The chair calls Lisa Bodwin.
Good morning. My name is Lisa Bodwin. I am testifying today as a private citizen, not as a paid policy professional. I rarely share personal stories in hearings, but HB 1730 and all of the death penalty bills, but 1730 in particular, are so profoundly ill-informed and misguided, I must. When I was 6 years old, a family member did unspeakable things to me that qualified as a capital crime under HB 1730. When my mother confronted the relevant family members, they took his side and ostracized us for a year. We were very poor, and from the next room, I heard the loud shouting. No police, no counseling. He became the protected center of the family story, not my trauma. Like nearly all families in this country, my reporting tore my family apart. Understand this, reporting is unimaginably hard. Like me, 75% of children know their predator. Speaking brought me isolation and punishment, not him. Research shows in states with capital punishment, the stakes are so high, reporting becomes suppressed. Families who know death is on the line create internal pressure to handle it privately. If New Hampshire raises the stakes to death, families will become more unwilling to report. And make no mistake about it, this is the most underreported crime in our country and in New Hampshire. Research on Louisiana's move to make child rape a capital offense found that the death penalty did not increase deterrence. What changed? Case processing, trials declined, plea bargaining increased, charges were more likely to be reduced or dismissed. I will provide that research to the committee. The system did not become more effective. It became more cautious, slower, and less transparent in Louisiana. Louisiana now protects defenders effectively. How dare the sponsors of this bill engage in the big government theater that does not protect children without having done his homework on what to do to address these evils. If the goal is protecting children, the death penalty does not increase the chance a child discloses, does not increase the chance a family reports. It does not make investigations faster or more accurate. It does not increase conviction rates, and it will not undo the trauma. If bill sponsors want to reduce violent sex offenses against children, like the little 6-year-old that I was, the boring path is competence, faster investigations, tighter supervision rules in youth settings, and stopping repeat offenders. The single best prevention. Men need to take responsibility to kill the cultural stories that give other men permission in the first place to abuse little 6-year-olds like me. Instead of dragging children and their families through years of court processes, use those same resources to prevent and restore victims. Focus on what we need. New Hampshire cannot execute our way out of these crimes that are usually hidden in families. Please vote in expedient to legislate on 1730 and all death penalty bills.
Thank you for your testimony this morning. The chair calls Mr. Paul Lutz if this is the bill you wanted to testify on. You didn't indicate the number. Paul Lutz. Oh.
Thank you, Mr. Chairman. Thank you, members of the committee, to give me the opportunity to speak today before you. A little bit of a background. I'm retired from law enforcement. I spent 30 years retired as a lieutenant. I spent my entire career in field operations on the street. I also was the regional commander of a special operations group in southern New Hampshire that covered 13 and does cover 13 cities and towns. I saw a lot of people die. I saw a lot of dead people in my life. Most police officers have no control over that. That's part of the job. I've actually seen people killed. Those things change your life forever until the day you die. There's nothing you can do about that. You're not the same person any longer. I've also seen victims. I've spoken to victims. I've spoken to victims immediately after a crime was perpetrated upon them, including children who suffered sexual assaults, very young children, sick. Very few things in life are sicker than one who would perpetrate an act like that. But you've topped it, because this bill is sicker. It doesn't ensure or try to assure justice. It reeks of vengeance, vitriol. Look at the wording. Look at the person who introduced it, not even aware of the constitutional prohibitions on capital punishment for crimes that don't result in a death. It's amazing. It's amazing that things in this bill borderline, if not completely cross into denying a person who is accused the right to put on an adequate defense. There are provisions in here that limit or exclude exculpatory evidence. I could not believe that. There's a statutory limit on how long the Supreme Court can take or even look at appeals. So that means that, sorry, you might be not guilty, but we're going to kill you right now because we ran out of time.
Sir, if you could just...
I'm sorry. I have a loud voice anyhow.
Okay.
I'm sorry.
You triggered my PTSD just a little bit.
I've been there with you. There was a question asked by the honorable legislator over there. I can't read his name, but it was a very good question about the appeals process. And I want to share this with you because I'm aware of the parties involved. Young police officer in Florida was murdered. His father was a New York City police lieutenant who was retired. He had to go, or chose to go, obviously, to the appeals for the death penalty because the person who murdered his son was sentenced to death. And the mandated appeals that were mandated by statute were numerous and went for a long period of time. And I don't have to add anything to his words. This is his father. NYPD lieutenant, not a cream puff. He said, why can't they just put him away and we can walk away and forget about him? Because every time I go to one of these hearings, my son is being killed again and again and again. That's just trauma adding to trauma. I would urge you all, please, to vote against this bill. Thank you very much.
Thank you for sharing your testimony with us. The chair calls Barbara Cashin.
Good afternoon. My name is Barbara Cashin. In 1985, I came to New Hampshire to work in the Attorney General's and prosecute homicide cases, and I stayed there for 5 years. In 1992, I joined the Public Defender's Office to defend homicide cases, and I stayed there for 14 years. So for 19 years, my law practice basically revolved around the crime of homicide. I think that I hold the record for having tried the most homicide cases in this state. I know I hold the record for having lost the most homicide cases in this state. When I was a prosecutor, one of the things I was assigned to do was to represent Robert Cushing, who was murdered. And I had the privilege at that point of meeting the Cushing family and having my life touch theirs. It changed my life. They're a remarkable family, and I'm grateful that I got to know them. I'm going to talk to you today about why it costs so much money. You've heard testimony from Mr. Dieter about how much these cases cost. They do. But I want to break down for you why they cost so much money. And in order to in preparation for this testimony today, I spoke with the head of the Public Defender's Office to find out how much what it took to represent the person that was ultimately convicted of killing Officer Briggs. And I spoke to the head of the Judicial Council, and I'll elucidate some of my own experience. But here we are. I'm going to pass out some testimony, not yet, Buzz. I want people to actually pay attention.
I resemble that remark.
Thank you. This will be in the materials that I give you. So the first thing I looked at was your fiscal note. And the Attorney General's, and all of these numbers I'm giving you, by the way, are monies that would be in addition to a typical homicide case, a first-degree homicide case. So the first thing is that the Attorney General's office says that it costs them an additional $2.5 million to prosecute a homicide case. And the reasons for that will become clear as I continue and talk a little bit about why it costs so much to defend such a case. By the way, I wanted to tell you that I have been involved in about 100 homicide cases, and one of them was a capital case. So I know a little bit about what I'm talking about.
May I just interrupt real quick, a question? In New Hampshire, is it always the public defender, or do they contract out these?
That's a great question. When I read the fiscal note, I was stunned to see that the Judicial Council and the public defender have contracted that the public defender will no longer handle capital cases. That shocked me. It's like, who the heck is going to be taking these cases? How are they going to be defended at all? And that's where you are now, trying to find people outside of the public defender's office to take on these cases, these bears of cases. And I'll talk to you a little bit more about how much you're gonna have to pay them. So the bulk of why these cases cost so much is attorney's fees. And the representing the Addison case, which was the last homicide, the last capital case, really the only capital case in the last 87 years that has resulted in a death sentence, anyone want to guess at how many hours of attorney's fees? Anyone want to guess at how many hours? 14,600 hours of lawyer work on this case. Why? Why would it take that much? First of all, in a typical homicide case, 2 lawyers are assigned. In a capital case, 4 lawyers are assigned because it's essentially 2 trials in one, as Mr. Dieter said. There's the guilt phase, and then there's the ultimately, assuming guilt, there's the sentencing phase, and that's a whole other trial. And I can tell you a little bit about that because in the one capital case that I was assigned to, that was in 1998, and it was the killing of Officer Jeremy Sharon. And I was assigned to represent Gordon Perry, who was one of the accused in that case. And that was my first and only touch on a capital case. And it's life-changing. It's nothing. I had done hundreds of cases at that point, homicide cases, 100. Nothing compared to that. But I'll tell you a little bit more about that. Anyhow, so you've got the rate now for reimbursing contract lawyers is $150 an hour. So if you take $14,000, multiply it by $150, that's $2.1 million at a minimum that it would take to defend someone in a capital case. And let me tell you, most lawyers, you're going to have to, if you get anyone to represent these cases, number one, they're going to have to be death-qualified lawyers. Just like you need death-qualified jurors, in order to be assigned a capital case, you have to be a death-qualified lawyer. Well, no one in the state, well, maybe 3 or 4 people, I'm one of them, is a death-qualified lawyer. And when I first was assigned to the Sharon case, I was not a death-qualified lawyer. I had to go to workshops and conferences to become educated in order to be a death-qualified homicide lawyer. That's money that is going to have to be spent. In order to have to try a case, you need to prepare the case. That means you need to speak to witnesses. You need to look at documents, you need to do all kinds of things. And in order to do that, you need an investigator. And in the case involving Officer Briggs, the last capital case, the investigator hours were 1,000 hours of investigator expense. That would have to come out of the budget somehow. And I don't know what the reimbursement rate is, so I didn't fill it in, but it's a lot of money. In any case, you have, especially a homicide case, you have to consider expert services. And I can't think of a homicide case I ever had where I didn't have to hire some kind of an expert. And I've included in this list a group of typical experts that you consider having in a homicide case: DNA experts, pathologists, serologists, fiber analysts, blood spatter, but it's unique to every single case. And I'll tell you that one of my favorite experts ever, I didn't even know they exist, was a forensic paleontologist. And so these expert services run the gamut, and they're very expensive. They are very, very expensive, and you have to have them. And in a case that involves a capital murder, the judge is going to let the defense have any defense expert that they need. Mitigation services. So what is a mitigation case? Number one, there's a whole jurisprudence that is death penalty jurisprudence. I didn't know anything about it before 1998. I knew that they had, there were Supreme Court cases, but I didn't read them because they weren't germane to my practice. But oh man, did I have to get educated when I got assigned a death penalty case. And one of the things that is required of death penalty defense is a mitigation specialist. That means, I'll tell you, in the case that I was assigned, for a year I worked on that case, and I did almost no legal work. I mean, I might have helped with some motions, might have done a little bit of, I had to read all the documents, but what I was assigned to do in that case was to be the attorney who would argue in the sentencing phase of the case. Should have come to that. So I spent all my time with the mitigation specialist. And the mitigations, these are people, forensic mitigation specialists. They are trained to reconstruct the defendant's life. And it is time consuming. It pulls you apart. And it costs a lot of money. I don't know, and again, I didn't put it in. I don't know what the cost of a mitigation specialist now, but I will tell you that I spent hundreds of hours with the mitigation specialist in the case that I was involved in. The other part of the case that I did, just to kind of throw in there, that I spent my time for that year, was working on mitigation, and also the other thing I was asked to research was botched executions. I mean, I spent a year having nightmares about botched executions. That's another story, but it did involve expert testimony and in meeting with experts, flying out of state to meet with experts, flying out of state to meet with witnesses. So I should have actually put in this expenses out of state travel. Because it's very expensive. You will need a consultant. You'll be entitled to one. And the appeals, I didn't even know where to begin with the appeals. I was at the sentencing hearing for Michael Addison, and I will never forget Michael Briggs' mother at the sentencing hearing turning to Michael Addison and saying, "From this day forward, I will say your name no more." And I thought to myself, oh my God, this woman has no idea what the next 2 decades are going to be like for her. And it has been 2 decades since Michael Addison was convicted, and there have been countless appeals. There are ongoing appeals. I don't see it ending in the near future. And this poor woman, you know, it used to be that you show up for hearings and there'd be a bunch of people there, lots of people from the Manchester police, and you know, prosecutors, Kelly Ayotte, whatever. And now you go to these hearings and it's me and Mrs. Addison. You know, it's horrible. And the other reason, expenses, I'll stop soon, but death qualified jurors, they cost more money. Death row, keeping them on death row costs more money. And we don't have an execution chamber in New Hampshire. And 10 years ago, they did a study, and I think the legislature commissioned it. How much would it cost to build an execution chamber? $1.8 million 10 years ago. So that's, nothing has gone down. The expenses only go up. So that's why these cases cost so much money. And you know, I think that when you are considering whether or not this is a good policy for New Hampshire, whether or not you morally oppose it or oppose the death penalty, whether or not you think that it's maybe should happen for some people, and you know, whatever you think about it, think about the cost and what you're asking the taxpayers to do, and other ways that the money could be spent.
Thank you. I have a question, if you don't mind taking a question, based on your experience. In researching this bill, I came across something that interested me. If someone who's accused of a capital crime like this manages to flee not only the jurisdiction of the state, but of the United States, are families sometimes denied justice because countries won't extradite them back to us because of the death penalty?
Well, yes. I mean, a lot of countries will not send people back to the United States if death penalty is a possibility for them. Yeah.
Thank you, Representative Scheer.
Thank you, Mr. Chair, and thank you, Barbara. As one of the other few, at least back in the day, death-eligible lawyers in the state.
Wait a second. You're not going to claim her as a former student?
She has the good fortune of not being a former student of mine. And having experience in the criminal justice system in New Hampshire for any number of years, this bill specifically focuses on people who are charged with sexual assault of someone under the age of 16. Could you give a rough estimate of how many people are charged with sexual assault of somebody under the age of 16 each year in New Hampshire?
No, I have no idea.
Fair to say it would probably at least be more than 30?
Again, I have no idea, but you know, we're looking at how many counties are there. You know, there's probably 20 or 30 cases a year in each county. It's a lot.
Okay. And and going to the cost issue, follow up. Going to the cost issue, let's say there were 100 cases statewide a year eligible for 1730 death sentence. The cost that you described would be for each case, not in total.
You're right.
Thank you.
Yes, Representative Lascelles.
Thanks for taking my question. Since the Addison case is fresh on your mind, is it possible to estimate how much his defense has cost through the years?
No, I tried to. I can tell you. I mean, the 14,000 hours, the public defender 8. So right away, $2.1 million would have gone to the Addison defense, and it didn't go to the Addison defense. I don't know. I did, when I spoke to the head of the Judicial Council, I asked him if he could put a number on it. And he said there wasn't a current number. I think the last number was like $3 million, something like that. But don't quote me on that. It was a lot, but it would have been a whole lot more under today's structure. And the appeals. I mean, I don't know how much the appeals have cost.
Follow up, Mr. Chairman. And in the Addison case, what's the end on the Addison case? How many more appeals? How many more years are involved in that?
I don't know. I think right now what is pending is ineffective assistance counsel claims that are filed in federal district court, and they have been filed for years without any action. I don't know why. So I don't know. I can't tell you. This is new for everyone. So I don't have answers.
I just have one more question. So in the appellate process, the convicted person has a right to appeal, obviously, through the state system.
Yes.
And then is it not true that then they begin the process anew in the federal system?
That's exactly what has
so
happened.
that you have retrials of the same appeal.
Yes.
Just on different constitutions. Is that correct?
Exactly. Exactly.
Representative Scher.
Just as a follow-up to that, broadly, the extent to which one would restrict the number of appeals, which are designed to make sure no mistake was made, the extent you restrict the number of appeals, you increase the risk that a mistake has been made. Is that fair to say?
Yes, and I think at some point you'll hear testimony from Andy Valinsky. Andy took the appeal of a person who was convicted of murder in Georgia. So he wasn't involved in the trial at all, but he worked on that case for 20 years after all state appeals had been done and going in back and forth to federal court. I mean...
So an attorney could make a career off of one case.
Yeah. They go on forever.
Thank you. Seeing no further questions, thank you for sharing that information. If you want to pass that out to Buzz, he'll get it the rest of it. The chair calls John Tobin.
Good morning. I have very short written testimony to pass around. Good morning, and thank you very much for the opportunity to speak to you, and especially after having watched these hearings yesterday and today, I have enormous respect for what you're trying to do and the burdens you're carrying. My name is John Tobin. I'm a resident of Concord. I'm 76 years old. I'm a retired lawyer. I've lived in New Hampshire for 50 years. I'm here to speak today in opposition to this bill and all of the death penalty bills. I speak, as others have, as a family member of a murder victim, and I must say it's a very sad but inspiring group to be part of. All of us wish with everything we had that we weren't part of it. And Representative Prue, I appreciate what you have been through. My sister Kathy, who was 2 years younger than I and was my closest sibling growing up, was murdered in 1981 at age 29 in an attempted robbery. She was stabbed to death. It was, and more than 40 years later, it still is the biggest and greatest shock and sorrow of my life. And I can't begin to describe the anguish and grief that my parents felt. A man was arrested, convicted, and executed for my sister's murder. His death penalty execution did not bring me closure or relief. It did not bring my sister back. I still miss her, I still mourn her, and I always will. This additional killing did not bring me peace. But what this deliberate taking of another person's life did do was spread the pain of death by violence to another family. It continued the cycle of violent death that began with my sister's murder. Make no mistake, murder is a horrible crime, and I can speak from sorrowful experience. The loss of a loved one to murder is total, it's permanent, it's indescribably bleak. Murderers should be punished, and the rest of us should be protected from murderers. Life imprisonment, locking up someone for the rest of their life, is a severe and complete punishment for murder. But another killing, this time by the state, is not the answer. Thank you.
Thank you for sharing with us this morning. The chair calls Margaret Hawthorne.
Good morning. I'm a little discombobulated. I'm Margaret Hawthorne. I am mother of Molly McDougall, who was murdered in Henniker, New Hampshire in 2010. I had planned to talk about 15 years out, my healing process, what I need and don't need to help me. But I need to talk instead. I need to object to the presentation yesterday by Representative King.
Unfortunately, I can't allow you to do that. I can only allow you to testify on the bill before us today.
Okay, I'll do that.
If you want to touch on it during that in relation to this bill, that would be okay. But as far as testifying about what other people said or did, I can't let you do that.
Okay.
As much as I would like to, and if you want to tell me outside after, I'd be happy.
I would very much like to do that.
Okay.
Thank you.
You're welcome.
Okay. So here we go. It breaks my heart to be doing this again. At age 14, living in a family that didn't seem to have a problem with it, I came to my own conclusion that the death penalty is wrong. And for me, that has never changed. And the possibility of being implicated in state-sanctioned murder is ghastly. My daughter, Molly McDougall, was murdered in her home in Henniker, New Hampshire in 2010. She was 3 weeks from finishing the nursing program right here in NHTI. At 31, she was happily married and looked forward to starting her career as an OR nurse. And the man who murdered her is serving 45 years to life. When I first testified against the death penalty in 2015, Molly's murder was still fresh and searing. I hadn't come to terms yet. I don't think I ever will, but I hadn't come to terms with outliving my daughter. Each morning, my waking thought was, Molly is dead. How do I get through this day? 15 years after her death, the pain has changed, but it hasn't gone away. It's a river of loss and despair, sadness that she missed watching 2 small nephews grow into young men, and regret that she didn't meet the 2 who were born after she died. In that river is also a channel of my deep gratitude for having had the joy of being Molly's mother. Death penalty proponents speak of closure. Rennie used to say, there is no closure. The only thing family members really want is to have their loved one back, and I agree with him. Rather than clutch at a futile hope for closure through violence, I want to swim in the river that holds it all. My faith relies on redemption, restoration, and forgiveness. I don't believe revenge and justice are the same. In my final semester I attended a Quaker seminary in Earlham School of Religion. In my final semester at seminary, I found myself ending a paper with this sentence: I believe in a divine justice that exceeds our petty imaginations. In other words, we don't know how it all works. It's more than we can fathom. It's better than anything we can dream up, and it reaches beyond our time on the planet. When it comes to deciding who should die, I'm willing to leave justice to God. I wonder who Molly would be now. She would have been a good nurse. She was happily married, and she talked about having children. But first, she and her husband wanted to do more traveling. So my yearning doesn't stop. I want more of Molly. The yearning wouldn't go away if the man who ended her life were executed. In my impact statement, I told him the best outcome for me would be to hear he had found ways to better his own lot and the lives of those around him. That's what I see as redemption. Pie in the sky, maybe. But that hope gives me the inner peace that I need to get through the days without Molly. An execution would eliminate any possibility of that turnaround. I don't need him to die to allow me to live. Thank you.
Thank you very much, and I'm sorry for your loss. Noel Bishop Merrill.
Good morning. Thank you for this opportunity to testify today. My name is Noah Bishop Merrill. I am a recorded Quaker minister, and I serve as denominational executive for the Association of Quaker Congregations across the northeastern United States, including all of those in New Hampshire. Quakers are called by God to oppose violence in all its forms, as inconsistent with our understanding of the will of God, who calls us to live in the virtue of that life and power that takes away the occasion for all violence, and calls us to be instruments of peace in a world held captive by violence. Yesterday marked exactly 2 years since we found my brother Justin brutally murdered. After countless slashing wounds, he had lost so much blood that it soaked through the wooden floorboards of his home, the subfloor, the joists beneath, and pooled in the basement below. I am intimately acquainted with the depth of the human capacity for evil. It is with this understanding and from it that I ask you to oppose any effort to reinstate the death penalty in New Hampshire, both HB 1730 and all related bills that would reinstate the death penalty. And for the purposes of testimony to this particular bill, I also want to acknowledge that, like others who have spoken so powerfully, I'm also a survivor of childhood sexual abuse. And those who have testified speak my heart and my experience. My testimony was instrumental in establishing the case against my brother Justin's killer. Had the death penalty been an option in the state where he was killed, it would almost certainly have been sought. I would have been caught between my commitment to justice and integrity in testifying and knowing I was being forced by the state against my will and my faith to be an instrument of the very violence that took my brother from us. As an ICU nurse For 23 years, my brother dedicated his life to saving lives. Allowing the tragedy of his death to be the justification for taking a life would profoundly dishonor his vocation and his legacy of service. Justin's murderer accepted a plea agreement, waiving his right to appeal. Had he been sentenced to death, as we have heard in so many others' testimony, our family might have spent our entire lives held captive to the uncertainties of the appeals process, forced to focus on the man who took Justin's life, rather than on the life my brother lived, who he was and is. I take solace knowing that my brother's killer will spend the rest of his life and have the rest of his life to consider his crimes. And if he chooses to find repentance and redemption in the hands of a merciful God, his execution would not restore Justin to us. It would instead rob our family of our agency to choose, for our part, to end the contagious evil his murder brought into the world. Reinstating capital punishment would not bring justice or healing. It would simply give state sanction to retribution and death. I urge you to oppose any effort to reinstate the death penalty in New Hampshire. Thank you for listening.
And thank you for sharing.
I have copies of testimony to share.
Yeah, if you could just pass them out to the representative on the end. The chair calls Sherry Young.
Almost good afternoon. Chairman and members of the committee. My name is Sherry Young, and I'm an attorney at the law firm of Rath, Young, and Pignatelli in Concord, New Hampshire. I also served on Governor Lynch's Death Penalty Study Commission in 2010. When I joined the commission, I had no preconceived judgment as to whether I was in favor of or against the death penalty. I attended the meetings with an open mind, listening carefully to the testimony and considering the evidence. At the end of an extensive and emotional set of hearings, I concluded that I was opposed to the death penalty for several reasons, all of which I think you've heard yesterday and today, but I will briefly summarize those reasons. 1, the overwhelming evidence before the commission did not demonstrate that the death penalty is a meaningful deterrent to the commission of murder. To the contrary, it appeared there is little to no scientific or statistical evidence to support such a claim. 2, putting a murderer to death through a state proceeding is not consistent with societal standards of decency, and the death penalty has been rejected by most of the Western world. The religious community throughout New Hampshire is united against it. 3, the decision to seek the death penalty can be arbitrary, unfair, and perhaps discriminatory, and therefore cannot be constitutionally applied. It is fraught with political and public pressures. 4, the cost to seeking the death penalty, as you've heard numerous times today and yesterday, are substantially greater than seeking a sentence of life without parole. Life without parole is an acceptable means of punishment. 5th and finally, to my great surprise, the testimony of the families of murder victims, as you've heard today, was overwhelmingly opposed to the death penalty. They believe that life without parole is an acceptable alternative and far better serves the interests of the families of murder victims, letting the healing process begin for those who themselves have been victimized. To conclude, in light of all the above, I favor the current law that has abolished the death penalty in New Hampshire in 2019 and hope you will oppose these bills. Thank you.
Thank you for your testimony.
I do have some written testimony. to
Yes,
submit.
by all means. The chair calls Phil McLaughlin.
My name is Phil McLaughlin. I'm from Laconia. Before making my brief statement, I want to say that I found it humbling to sit here and listen to these testimonies. Humbling. I was Attorney General of New Hampshire for almost 6 years between 1997 and Christmas of 2002. You may remember some of the events of those years, and some may be relevant to the issue today. During that time frame, there were about 80 murders in New Hampshire, an historically large number for a 6-year time frame. I supervised many murder investigations and prosecutions. I was close to scenes of violence, mostly through photographs, close also to the impact of violence on families and friends, sometimes through personal conversations. One conversation was with the mom of a 6-year-old Elizabeth Knapp, who had been raped and murdered in Hopkinton on July 3rd, 1997. Another with the mom and dad of a young officer, Jeremy Sharon, killed in Epsom on August 22nd, 1997. Jeremy was a former Marine, like 2 of my sons. 3 days before Jeremy's death, on August 19th, 1997, in Colebrook, Carl Drager killed a judge, a newspaperman, and 2 troopers. Drager died in a shootout. The citizens of New Hampshire were outraged by this series of events, you may remember. In the shadow of that outrage, the Knapp and Sharon murders set in motion investigations that, but for events, may have led to the death penalty. In the case of Elizabeth Knapp, poor investigation led first to the arrest and public vilification of an innocent man. Good investigation led to the conviction and life imprisonment of her killer. In the case of Jeremy Sharon, terrible prosecution decisions led to the withdrawal of death charges against his murderer and to his being sentenced to life without parole. In my observation, over almost 6 years in office, all murder victims' families were alike in their shock and sorrow, but the 2 I just mentioned had also to bear the media attention associated with the red-hot capital punishment debate. The people of this state have all been similarly horrified by past murders and will be by the next, but they generally accept that justice normally and calmly runs its course. Not so in capital cases, certainly not in the 2 I managed. No calm there. The prospect of the death penalty left many good citizens infuriated with those who held opposing opinions. It affected people's judgment. New Hampshire today has a criminal process that works very well, is supported by the vast majority of our citizens, and has stood the test of time. We have not executed anyone in nearly 100 years, and today there are about 80 prisoners doing life without parole. We live in one of the safest states in the nation. It's understandable that some want to fundamentally change this process. It is left to you to decide the wisdom of doing so. In casting your vote, please be less governed by the outrage we all feel toward a murderer. Consider first and foremost the duty we owe to the families of the deceased to competently investigate and prosecute each case. Consider most especially how we can respect their privacy, give them the time and space needed to manage their grief, and shield them to the extent possible from the inevitable pressures and notoriety associated with the criminal justice process itself. Thank you.
Thank you for your service to the state and your testimony today. Representative Scher.
Very briefly, fair to say, but for DNA, the DNA testing results in the Elizabeth Knapp case that the wrong person may have been subject to the death penalty?
It's a possibility, but there were other factors in addition to the DNA associated with James Dale that caused us, to turn in a different direction. One of them was listening to the interrogation of the mom, Ruth Knapp, and what was done to elicit from her a statement fingering this poor bugger that we arrested.
That interrogation lasted 8 hours, I think it was.
I don't remember the length. I remember the substance, and I remember the things said to her that, in my view, caused her to make the statement she made. And I don't think I've ever said that before.
Okay, I think it's safe to say that the wrong person could have been faced the death penalty.
There's no question that that was the direction the state was taking.
Thank you very much.
I didn't do this 20 years ago.
The chair calls Griselli's Glen, if I said that right. Probably not. All right.
You almost, I think you got it almost, Griselli. Good afternoon. My name's Griselli, and that scripture that you mentioned, the vengeance, it's in Romans and it's in Deuteronomy. I just wanted to say that. My name's Griselli, and I'm here to speak to you not only as an advocate for my community, but as a survivor of sexual assault. Beginning at the age of 8, at the beginning of the age of 8, I was sexually abused most of my childhood, all the way up until I was a teenager, so 15 or 16 years old. And that experience took away my childhood, my innocence. It impacted everything about who I became, how I see the world, how I trust people, how I carry myself. It damaged my sense of safety and security. It stole parts of me that I will never get back, and it left me with scars that I still live with today. So when I say that I understand the pain and the anger that comes from crimes like these, I truly do. I know what it's like to live with the trauma. I know the anger, the confusion, and the silence that follows. At the same time, I need you all to understand this. Even after everything that was taken from me, everything I've endured, and everything that I've overcome, the Jesus in me will not allow me to support a law that would put a person to death and call it justice. And while I understand the outrage behind it, I want to be very clear that this bill does not speak for all survivors. It certainly does not speak for me, because no execution, no matter how it's carried out, can undo what's already been done. Taking another life doesn't repair the damage or bring back what was lost. It doesn't rebuild trust or restore peace to the ones that left behind. And to all the people that I hear and see, that they kill the pedophiles and to kill the rapists and that they deserve to die, I want to say this. If you really cared about protecting children, you would be doing something to prevent this from happening in the first place. You would be fighting for real change in the systems like DCYF, for example, where children are removed from their parents, from homes, without any accountability, without any evidence, or without any proof of any kind except for their word against the parents. Passed through foster care, passed through group homes, gone to detention centers, and too many times, they are abused in those places. And as we know from the innumerable amount of cases in the YDC cases, but it seems that there is a pattern of protecting those in positions of power and authority far too much. If we truly cared about protecting children, we'd be fixing those systems, not pretending that killing one person somehow solves the problem. Because killing someone for hurting a child doesn't stop child abuse. It doesn't prevent child abuse. It doesn't protect another child from being harmed tomorrow. So all of that anger about protecting the kids, it means nothing if it's not backed up by action, compassion, and real solutions. It's taking another human's life brings someone some type of gratification or relief or some type of justification, then if it feels like closure, then that's a sign of a deeper pain that still needs to healing. Because real healing doesn't come from revenge or conviction or death. It comes from forgiveness. And forgiveness isn't for the other person, it's for ourselves. It's about freeing your heart from the hold and that pain and the anger that they have on you. I believe in God, and I believe that He is the creator of all things, the only one who decides when life begins and when it ends. If we start deciding who deserves to live or die, that we're stepping into the role that belongs only to Him. God forgives us over and over again, even when we don't deserve it, and He calls us to do the same. If we can't forgive, then we're blocking the same grace that we ask Him to show us. But beyond faith, there's something practical too. Hurt people hurt people. When you treat people like they're less than, when you lock them in cages for years, focus on only punishment instead of understanding or rehabilitation, you create more brokenness. You create more pain. If we as a society focused on restorative measures, on real healing, prevention, and accountability, maybe the future would have more of a chance. But at the rate that we're going, that chance gets smaller and smaller because it feels like we're going backwards, back to the barbaric times, back to the colonial era. And that's exactly where the death penalty came from. We didn't choose it, we inherited it. We are supposed to learn from the past, not repeat it. And if the state truly cares about survivors, it should focus on restoring lives, protecting children, and building a safer future. Not ending lives in the name of justice. Execution will never heal what's been broken. It only keeps the wound open. That's not what survivors need. That's not what God asks of us, and that's not who New Hampshire should become. Thank you.
Thank you very much, and I apologize for missing it by that much.
You'll get it next time.
The chair calls Emily Garrett. Or is it Gerard?
Good afternoon. My name is Emily Garrod. I am the Stratford County Attorney. Thank you all for the ability to speak today. As I mentioned, I'm the Stratford County Attorney, meaning I'm in charge of the felony prosecution for all the crimes in Stratford County. I've been a prosecutor myself for 10 years in that office. During my time there, I have seen hundreds of cases of child sex assault come through, and I myself have personally prosecuted, and I was trying to put an estimate on it, probably upwards of 50. I pled one out on Tuesday. I have one on trial next month. I think maybe as much as anybody, I have a good familiarity with the AFSA statutes. And I'd like to talk about something that really hasn't been addressed with this bill yet today, and that is some of the other changes that is making to the AFSA statute. Part of the changes this bill proposes is taking anybody, any victim under the age of 16, including acts of penetration, and adding it to the AFSA statute. Previously, it was victims under 13, as well as forcible sexual assaults, non-consensual sexual assaults, things of that nature. In doing this, you were taking what was previously misdemeanors and felonious sexual assaults and making them aggravated felonious sexual assaults. My issue, and one of the main reasons I oppose this bill, is I think that there are some unintended consequences in doing that that weakens the AFSA statute. As a person that practices his almost on a daily basis, I have to tell you that there is a spectrum of egregiousness when it comes to sexual assaults, as sterile as that sounds to say. You have the most egregious, which would be sex assaults on very young children. And on the other end of that spectrum would be what we call statutory cases, cases of teenagers engaging in what would otherwise be considered consensual sex with people that are above the age of consent. And what this crime does is takes that group of this statutory cases and lumps it into AFSA when it previously wasn't. In doing that, I think the unintended consequence is that it weakens the power of the AFSA conviction, which was previously the most egregious, the most terrible sexual assaults, and adds to it this layer of cases which a lot of people don't consider to be as serious. I have to ask if it was considered by the person that drafted this statute that in drafting this statute, they have essentially made a 15-year-old sophomore who has sex with their senior 18-year-old boyfriend. That crime is now in AFSA. It is now punishable, even taking the capital punishment piece aside, by 25 to life with lifetime registration. Even I, who consider these crimes to be so egregious, who is consistently in court advocating for harsher punishments, even I consider that to be far too harsh. of a punishment for somebody of that age group. There's no carve out for what we call the Romeo and Juliet carve out. For say a 15-year-old that has sex with a 40-year-old, it's the same punishment for a 15-year-old that has sex with a 16-year-old. And now we're talking about filing juvenile petitions for those sort of cases as well. What also happens when you have a 15-year-old who has sex with a 15-year-old? There's no carve out for that or exception to that. So are you filing juvenile petitions for aggravated felonious sexual assault in those cases? Are you trying to try them as adults so that you can seek more serious penalties? You're putting a lot on prosecutorial discretion that I think wasn't there before. And I think these are all some unintended consequences of the other aspects of change to this bill that need to seriously be considered. Moving to the capital offense piece, I'm going to not cover what everyone else has covered here today because I think they've all done a wonderful job. But I will say from the county prosecutor perspective, it's not clear to me who would be prosecuting these capital crimes. Typically, capital crimes are murders, so they're prosecuted by the Attorney General's office. However, the county attorney's offices are tasked with prosecuting child AFSAs at this moment. So would they be giving that authority to the county offices? I'm not sure. That's a question for the Attorney General's office. I don't want to speak for them, but I cannot imagine they have the resources to take on the number of child sex assault cases that we get, which is extensive and would frankly break your heart if you could just see the amount of these cases that come through. These cases already are labor intensive. They are resource intensive. My office does not have the resources to prosecute these cases. We do not have the manpower to prosecute capital cases, especially knowing the amount of these cases that we have in our offices that come through every year. We have staffing shortages across the state with prosecutors, and that's not even adding into the piece where now we'd have to be looking for prosecutors who are not morally opposed to the job. So all of those things I think need to be considered before making these changes to the statute, and I'll take any questions that anybody has.
Thank you. So to be clear, as someone who attempts to put people guilty of these crimes in jail every day, you're not asking for this type of discretion that it would grant.
No, sir. I think there are a lot more realistic minor changes that could be made to these statutes. And that if anybody during filing period has any questions about that, I'd be happy to brainstorm with them.
Forget not the amendment. Also, I would ask, with regard to the burden on the courts, it's my understanding our courts are underwater, so to speak. What would this do to our courts? I mean, is one of them currently a circuit court crime, and that would now have to go to a superior court? I mean, what would after felonies first is gone now? So
yeah, I think most prosecutors' offices would bring any sex assault case in superior court, so not have to re-traumatize the victim if they had to be appealed to superior court. But I can just tell from my practice that these cases drag on already. We have the trial period, we have the conviction, we have the appeal, we have the ineffective claim, we have the 65120 sentence reduction hearings. All of those are re-traumatizing to a victim every time because we're required by statute to reach out to say, hey, they filed this notice, they want to do this with their case, they want to reduce their sentence. It is already a drag on the courts in that respect. And that's just from my perspective. I don't work for the courts, of course. But it is a clog to the system already. These cases, as I said, they take a long time to go through the system because they do deserve the attention that they get from both parties and from the court.
okay. There's other questions, but I'd be happy to talk with you about some of the things that we should be doing. Representative Scher, please.
For the chair's benefit, this witness attended UNH Law, but had the good fortune not to take. She dodged me. That's right. She took no courses from me. Could you give an estimate in a year how many sexual assaults of children under the age of 16 your office prosecutes?
Prosecutes or processes? Because there are cases there are cases which unfortunately we can't go forward on for whatever reason. But I would say I personally review 30, and I have 10 felony attorneys in my office. So, you know, ones they're seeing in court, when the court did their fiscal impact, they're only seeing the ones that are filed, not the ones that are processed. I also oversee my county's Child Advocacy Center. They do something like, I want to say like over 400 interviews of children suspected of abuse a year. So, I mean, it's an overwhelming number, and the resources that these cases already take, it's just, it would not work to have to do capital crimes for all of them.
Thank you.
Any other questions?
Anyone else?
Thank you for this opportunity.
Thank you for coming in. And the chair calls Attorney Stephen Enders.
I think all the points I was going to make have been made, so I'm happy to sit quietly. Thank you.
Thank you very much. With
Uncharacteristic.
that, we have no one else signed up to testify. So I'm going to go ahead and close the public hearing on HB, let me put my glasses down, 1730. Who's that? Don't you do that to me, Joe. We are going to take, let me see, our lunch. Yeah. Yeah, we're just going to take a 10-minute bio break, and then we're going to come back in and see if we can't knock out a couple other quick ones. I want to thank everyone who came in today to share with us today. Regardless of what side you come down on this issue, I know it's very painful and difficult to share these things publicly. So thank you very much.
Good to see you again. Good to see you.
Okay, I'm opening the public hearing on House Bill 1670 and invite the sponsor to introduce the bill. Oh, wait a minute, excuse me. 1556. I was optimistic. So,
Thank you, Mr. Chair, and thank you to the rest of the members of the committee. I know this has been a long day. My name is Lori Corzin, and I represent Coos County District 7. I bring this bill forward because while our state recognizes that domestic abuse victims need protection, our statutes fall short in recognizing some of our most vulnerable witnesses to that violence, and those are our kids. My husband and I were foster and adoptive parents for over 20 years, and we have seen firsthand how this cycle of abuse is passed from one generation to the next. We met our oldest son when he was 10 years old. We fostered him for 2 years before we were allowed to adopt him. Before joining our family, he was exposed to all kinds of abuse and neglect. He was an innocent little boy with a big but broken heart. That innocent little boy is now a 34-year-old who's sitting in our county jail. He is awaiting trial for multiple domestic abuse charges. Please don't misunderstand. I love my son and I always will. I'll always be there to support him. But today I'm here to take a stand for the next generation. I will not make excuses for the behavior of an adult. Behaviors must have consequences. I will pour out my heart and soul into my 2 little grandsons, who unfortunately were witnesses to that abuse. Those 2 little boys now live with me and I'm helping to raise them. We will do everything in our power to stop this cycle of generational abuse and neglect, which normalizes fear and anger and violence. Until our laws recognize the children in these situations as victims and not just passive bystanders, we risk becoming accomplices to the next generation of abusers. Abuse thrives in silence, acceptance, and excuses. We must build a New Hampshire where children grow up knowing that love does not equal fear. The cycle must stop with us. If we're serious about helping children, we must be honest about what exposure to domestic violence does to them, emotionally, developmentally, and across generations. Unfortunately, New Hampshire lags behind 31 other states in our nation that have specific laws addressing domestic or intimate partner violence committed in the presence of a child. Those states have decided that when an offender chooses to commit violence in front of a child, that added harm matters. It is time for New Hampshire to do the same, to stand up and say that we will no longer turn a blind eye to intergenerational abuse. This bill establishes a narrowly focused sentencing enhancement when a domestic offense is committed in the presence of a child. The enhancement is very modest, adding just a limited term to a sentence, but symbolically it is powerful. It says that children's trauma matters. It says we will no longer look past the smallest people in the room. This legislation was developed with care to ensure it is targeted, fair, and respectful of victims. It does two key things that I want to underscore. First and foremost, this bill does not criminalize the victims. It is aimed at the offending partner, not the non-offending parent, and it is not a vehicle for punishing the parent who is already being abused. And second, it builds training and guidance. Law enforcement will receive training on how to identify and document when a child is present, so these cases are handled consistently and carefully across our state. With this act, we can take a stand against normalizing abuse for our future generations. We have to recognize it and we have to deter it. Colleagues, I respectfully ask for your thoughtful consideration and your support on this bill. Let us be clear that in New Hampshire, we will not shield the abusers. We will shield our children. Every policy we pass and every protection we strengthen should send the same message. Abuse must end here and now in New Hampshire. Thank you.
Thank you. I have a couple of questions, if you would.
I'm going to try my best.
Okay. So unless you have somebody prepared to testify about the actual law itself.
I don't think so. Others will come after me.
Okay.
Yes.
All right. So it looks like in a quick reading of the bill, you're adding 6 months to a sentence if it's a misdemeanor. Is that correct?
That's correct.
And then if it's a felony, you're adding how much?
Just again, 30
Another
to
6
60
months.
days.
Oh, okay.
Yeah.
Oh, 60 days.
Yes.
Okay. And the trigger for that is there being a child present when the domestic violence occurs. And that's
Yes.
separate and apart from any domestic violence perpetrated on the child, correct?
Correct.
So my question is, what percentage of domestic violence occurs where there's a child present? 'Cause it seems to me that would be the majority, if not.
It is the majority.
Okay,
And I
so-
think that's why laws like this are needed.
Yeah.
I think that in order to change the next generation, we have to start somewhere and we
Sure.
have to take it serious.
Sure. Well, I guess what I was wondering is, would it not be easier to just increase the penalty for domestic violence versus?
I
And ma-
think it's important that people understand that this is added for the children,
Okay.
not necessarily for the person who's being abused, but it's for the children. It's
Okay.
just a step in saying that this is wrong. You can't normalize this behavior and then expect healthy adults to walk around in society.
Okay. I understand your intent. I was just trying to figure out the semantics.
Sure,
Thank you very
sure.
much. Anyone else have a question? Seeing none. Thank you very much.
Thank you.
Alex Holobinko? Did I get it right? Good.
Awesome. Hi, my name is Alex Holobinko. First and foremost, I'm a father, full-time student. I'm also pursuing my national advocacy and credential program with the federal government. That kind of came around because I am both a victim and survivor of domestic violence, as well as my daughter. Some of you may have seen a petition my daughter and I pursued, the Infinite Stars Law petition, which actually touched base with a lot of stuff Lori Corzine was kind of pursuing as well. After going through Lori Corzine's actual bill, I found there's a lot in there that really needs to be pushed forward even further. So children in general are pretty much anything that occurs around a child is going to stay with them for life. They're all their experiences, how domestic violence and stuff like that. The cost of that increases further and further as they go. Using the CDC's Kaiser studies, it shows that any exposure to domestic violence actually inhibits their brain and their patterns and forces them later on in life to incur substance abuse, sexual abuse, and they reenact these upon other people. And then society has to incur those costs as well. So if we can establish a way to kind of mitigate that prior to going forward, that'd be absolutely great because we can save a lot of adults before they even get to the point of being adults. And from when I read the actual bill itself, from what I understood of it is each individual child is an additional charge attached on top of that. And in July of 2025, the Supreme Court already acknowledged that it being a witness to a domestic violence, if you're domestically related to the victim itself, makes you now a victim of domestic violence. And if we establish that with Joshua's Law as well, and what actual constitutes as domestic violence on top of that, then the actual bills being presented would actually help suffice and provide a lot more protection for children in general. I feel David Love's original petition or bill that got tabled a bit ago would give great support to this one as well, allowing children to be protected even before the DCY or anything like that get involved. So if we have abuse and bring that all together, then we'd have Lori Corzine's bill at the end, providing even further statutes and limitations for people that honestly they should be on registry, but that's for another point in time. But a lot of these things really are destroying children, and those children are going to destroy the building blocks we need for their future and stuff like that. So we're going to sit here and basically, there's a lot of programs, but not a lot of programs people know about. And if we can bring those programs in further, like the federal government has a lot of like advocacy programs that unless you know about them, and unless these programs can kind of get brought in through these bills as well, there's not much we can really do except for let these kids go through school programs, go to counseling, go to therapy, and like incur all the costs, and then expose this and commit these acts to their own partners. This is not a men commit these crimes. This is everybody kind of commits the crimes, and I want to make sure that's kind of like one of those things that are acknowledged across the entire board. Sexual abuse is not just male only, and it's also females do it, and domestic violence is both men and women across the entire board. And by establishing such, then we can kind of protect our children a little bit better. I think that's pretty much about it right there.
And I agree, violence begets violence. It doesn't matter what your sex is. Thank you for your testimony. Oh, sir, would you hold for one question?
Thank you for taking my question. I just was wondering if you know the bill number for Representative Love's legislation that you referenced.
I have it somewhere in message. I think it's like 756. It was last year. It was
Last year.
tabled.
Okay.
In the House or the Senate?
It was in the House.
Okay. Thank you.
The chair calls Pamela Kylik from the coalition. Absolutely. That's why we have that big comfy chair.
Good afternoon, Mr. Chair and members of the committee. My name is Pamela Kylig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As you know, we're the umbrella organization for the state's 12 crisis centers, who serve nearly between 13,000 and 15,000 survivors of sexual and domestic violence every year. We are here to speak in support of HB 1556 and really appreciate the sponsor for bringing this important issue before you. This bill, as you've heard, would create the offense of committing domestic violence in the presence of a child. And thank you so much for the opportunity to speak today. The coalition recognizes the importance of intervening in cases where children have been exposed to violence in their homes. It is vital that children receive support and that protective caregivers receive the assistance they need to establish a safe environment. And so for these reasons, we are fervently behind the goals of this bill, and we recognize the long-term impact and harm that comes from witnessing domestic violence in childhood, as some of the previous speakers have highlighted. Joy here is the program director at the coalition and works with our staff to implement the Family Violence Prevention Specialist program, which has been operating since 1997. The Department of Health and Human Services partners with us to ensure that we're improving interventions for families that are experiencing violence. So she is very, very familiar with the dynamics of these types of instances. And so I thought her expertise might be valuable to the committee. Last year, from October 2024 to September 2025, more than 800 adult victims were served as a result of referrals from the child protection workers to family violence prevention specialist advocates. So I think just wanted to really highlight that this is a really prevalent issue in the state, and it's great that it's being addressed. One thing I would like to note is that in preparing for today and speaking with some other folks who are going to come and testify, there might be a couple a streamlined approach that we can, if the sponsor is amenable to looking at a slight amendment to the bill, just to make sure that this is an effective policy and that can be prosecuted. And
I think I'm going to appoint a subcommittee on this bill.
Okay,
anyway,
perfect.
just
Yeah,
so-
we definitely want this to move forward. We just want to make sure all questions are being addressed.
And I have many. So I'm
Okay.
hoping Attorney Enders is going to testify on this.
Yes,
bill. Yeah.
thank you.
Thank you.
All right, I'll turn it over to my colleague.
Thank you so much, Pamela. Thank you all for having us. So there are countless long-term physical, emotional, behavior, and developmental consequences for children exposed to domestic violence across all stages of childhood development. And we know that childhood exposure to domestic violence has been studied as a key adverse childhood experience, or ACEs. Many of you might be familiar with that. And that placing children at increased risk for substance use, domestic and dating violence, victimization and perpetration, and physical and mental health challenges throughout adolescence and into their adulthood. we recognize that learning how to identify adverse childhood experiences and putting supports for children at the early age is critical to breaking the cycle of abuse. And that's a big part of what our Family Violence Prevention Specialist program is to get those early interventions with families and provide that ongoing support through the process of working with DCYF. Domestic violence survivor parents really do the best that they can to shield their children from this harm, and they often are taking really unique approaches to ensure safety. They really know their situation best and how to keep their children safe within the context of domestic violence in the home. But we do know that children's exposure becomes inevitable as the cycle of violence becomes more frequent and more severe over time, and this is entirely the responsibility of the person who has chosen to commit those acts of violence in the presence of their children. So HB 1556 really aligns with the DCYF domestic violence protocol, which emphasizes that accountability for the perpetrator of domestic violence and the safety for the adult victim and the child victim. Accountability really needs to address the abuse that occurs when children witness and when they hear domestic violence happening. Adopting legislation like HB 1556 will certainly help clarify best practice when it comes to supporting protective parents and holding perpetrators accountable. Unfortunately, we have seen a lot of instances where children are removed from the homes where domestic violence is present, and reunification happens for the perpetrator before the protective parent is reunified with the child. And often survivors' barriers to reunification are exacerbated by the lasting impacts of the trauma of domestic violence and by financial abuse that occurs like universally within domestic violence cases. So it's very complex, and certainly we recognize that that exposure is continual.
And just briefly, the one piece that I think we were going to speak to in terms of considering for an amendment is just the mandatory reporting piece. I won't go into detail because there will be a subcommittee, but I just wanted to flag that that was something that could be explored a little bit more to just make sure there wouldn't be any unintended consequences. But yeah, in conclusion, we are just really grateful to see this being brought forward in the legislature, and we're ready and willing to work with the committee so that we can move something forward this year. Thank you so much.
Thank you. I have a question. In your experience, in a home where there's domestic violence being perpetrated against a parent, is it not the case that it's more often than not also being perpetrated against the child, not just that they're being exposed to it, but they're also being abused?
I think that there's a very high likelihood that the child is also potentially being abused in those cases.
Okay. All right. Thank you.
Mhm.
And further, oh yes, Representative Muse.
Thanks. Do you think there's any risk at all, given the way the bill is structured, that some people may be less willing to report incidents of domestic violence because, and I know this cuts both ways. In some cases, people may want the person to be in jail longer, but I do know that that's a very real factor with a lot of victims, and I'm just curious what you think about that.
I think, again, the work that we do with survivors, it really is meeting people where they're at. A lot of our victim advocates work extensively with people before reporting even happens. It is a slow process, and I think that we are always going to have to contend with people being hesitant to report. And seek support and safety. That is the dynamics of domestic violence.
But I think something to consider is that one of the reasons that people don't come forward is because they don't know what's going to happen to their child. And so the fear of retaliation and then the consequences of that. And so there is a protective element into showing that the perpetrator will indeed actually be held accountable for the violence they're committing in the home, versus it maybe seeming like they're a bad parent for not protecting their child, if that makes sense. So I think it's a very complex issue, and I think you're raising one element of the many, many factors that could, limit someone's feeling safe to come forward, but I think there's a much broader array of considerations as well. Thank you.
Thank you. And once I appoint the subcommittee, I anticipate you'll want to work with them. So
Perfect. Thank you so much.
thank you very
everyone.
much.
Thank you.
The chair calls Mary Kruger.
Thank you, Mr. Chair, and thank you, members of the committee. My name is Mary Kruger. I'm an attorney with New Hampshire Legal Assistance. We're a statewide nonprofit law firm. We provide civil legal services to low-income clients and aging clients to meet their basic needs, including freedom from domestic violence, stalking, and sexual assault. We have a domestic violence advocacy project. I'm a supervising attorney on that project, and I've been in practice for about 20 years. We handle protection order cases in family court, as well as divorce and parenting cases. So I'm really coming at this from like the civil perspective. I'm not a prosecutor. I don't have any of that background. And so I do want to just speak to some of the really positive things in this bill, and we are in support of this bill. And I do think that it could use a little bit of changes as well. So we'd be happy to work on that if the committee is so inclined to invite us to do that. The positive things I see with this is one, it really is recognizing domestic violence as a public health problem, and that is exactly what it is. When we look at the impact that domestic violence and exposure to it has on children, we have heard some of the consequences of children experiencing both short-term and long-term consequences for children who have experienced and been exposed to domestic violence in the home. This codifies that as an issue, and that's really important because I think, especially in the family court side of things too, the impact of exposure to domestic violence on children is huge, but we don't have a lot in our law to really sort of describe why that ought to be itself something that perpetrators of domestic violence ought to be held accountable for. And creating that additional accountability for perpetrators having exposed their children to these crimes, I think goes a long way to help children to be free from being exposed to these types of abuses. And the bill also describes witnessing in a broad way, which is really important because a child may not see, they may not even hear domestic violence happen, but they can still see the consequences. They may see the injuries on the victim parent. They may see holes in the wall. They may see broken glass or other things in the home. They're going to see that the victim has been impacted themselves by the trauma that they've suffered being a victim, and that impacts their ability to be emotionally available for their children and all kinds of things like that. And holding the abuser accountable for these things is very important to do. I do think that some things that the committee could think about is some restorative practices that could also be infused into this, because one of the questions earlier talked about, is increased jail time really what victims will want? Some victims are very concerned about finances. They maybe haven't been able to work, and they're relying on the abuser's income to support children. And that may be a strong reason where they don't want a lot of jail time, but they want accountability. And so there's other ways to have accountability. And I do think we need to build a system that where there are services available to, like, batter intervention programs that are evidence-based, that we used to have, 20 years ago in this state, widely available. And now we have, I think, 2 actual programs that are available, and things like that will help to do what we're talking about here, which is stopping that cycle of abuse from going forward. And then certainly services for the child victims to keep them safe, to help them to overcome the trauma they've experienced, and the victims themselves to have that support, to be able to have that agency to do the things that they need to do in order to stay safe and be free from violence. We have the fortunate experience at NHLA of representing victims when they've made that decision to leave. That's a huge and hard decision for them to make. And it can be really difficult trying to manage and navigate the systems that we currently have, where I've had clients say to me, I probably should have just stayed. And we should not have anyone saying that when they are choosing to remain in a violent situation over being free from violence. So we really do need to make sure that we have the resources available to support those victims when they are escaping. So I think that this bill really is a step forward in helping to recognize the problem of exposure for children. And so we do support HB 1670. Thank you.
Thank you for your testimony. Representative Scher.
Thank you. Again, former student. I'm
But
looking.
I knew Buzz before I went to law school.
That's right.
I'm
Just-
wondering how
okay.
far I have to move away from New Hampshire to avoid former student.
I went to the law school despite knowing he was there.
That changes my questions to the. I'm looking at the bill, the first page, lines 22 and 23, which say the court shall impose a mandatory minimum sentence of not less than 30 days imprisonment. And picked up on what you said about the financial resources that may or may not be available to a victim of domestic violence if the perpetrator is definitely going to jail for 30 days. Are you in support of having that mandatory minimum, or would you be willing to consider modifying that?
I would be willing to consider modifying it. I will say I probably differ from my prosecutor friends on some of this, and that's where we may come into sort of like issues. I do think there is evidence to support that having some jail time is a very effective way to really help an abuser understand that what they have done is not acceptable. And so I think 30 days, yeah, that's probably a good way to signal to somebody, we're serious. This is not okay. These crimes are not okay. You shouldn't be doing them, period. You shouldn't be doing them in front of your children, period. And so I think I'd come down on the side of, sure, 30 days, like, let's hold this person accountable. And it also makes it more effective then to have like a suspended sentence, because now you sort of know what you're up against, right? And you know that because one problem we have is when people have really no accountability and they think they can continue to get away with this. And I see that more in my practice than the opposite.
Thank you.
Thank you. And thank you for your testimony.
Thank you.
Attorney Steve Enders.
Good afternoon, Chairman, members of the committee. My name is Stephen Endres. I'm an attorney in Concord who's been practicing criminal law for around 25 years. I echo the sentiment that I think this is a great idea, and I think it's a worthy cause. I read once regarding intimate partner violence, something that really sort of struck me, which was that people that experience intimate partner violence have post-traumatic stress disorder at a much higher rate than other victims of crime. And they sort of explain that if you're in an intimate relationship with a person, the idea that that person is purposely trying to hurt you is very difficult to comprehend. And that makes sense to me. And certainly, when you look at the relationship of parents and children, obviously children are looking to their parents for protection, for support, for all of their needs. And if your parent is committing violence against your other parent or against you, that again is extremely hard to comprehend. I do, again, think this is a fantastic idea. I think there may be some tweaks in the language that could be made, specifically with reference to this creating enhanced sentences. In New Hampshire, as you all know, there's a circuit court which prosecutes misdemeanor charges, and there's a superior court which prosecutes felony charges. The circuit court only has jurisdiction for charges that carry a sentence of up to 12 months in the House of Corrections. If we were to make domestic violence in front of children have a potential 18-month sentence, it would exceed the jurisdiction of the circuit court, so it would then have to go to superior court in the first instance.
Allow me just to quick interrupt,
Yep.
so I don't forget. But if we were to keep the sentence but make a portion of it mandatory, it would still stay within.
If you had any, well, yes, if you had
If
a
I'm still within
mandatory
that.
sentence within that 12 months,
Right.
it would still say in circuit court.
Okay.
But as soon as you exceed that 12-month
Right.
barrier, let's say, it would then have to go to superior court.
Right. But if we said anything less than 12 months, but 30 days mandatory, it still stays in the.
Absolutely, it would still stay in circuit court.
Okay. Thank you for the clarification.
I also, from my experience in domestic violence cases, I don't think we're seeing a lot of 12-month sentences. I can't think of a time or more than one time where a judge has imposed a 12-month sentence and essentially said, if I could give you more, I would. Normally, if the conduct is that egregious, we're getting into felony land to begin with. Sort of the same thing with the Class B felonies, increasing the minimum by 6 months and the maximum by a year. I don't think we see a lot of people being maxed out on felony domestic violence, so I don't know that adding another year would necessarily be effective. With reference to Attorney Scher's question regarding the minimum mandatories of not less than 30 days imprisonment, I don't really like minimum mandatories. I think that I like the idea that a judge is the person who is sentencing. And unfortunately, whenever you have minimum mandatories, what ends up happening is it moves the discretion from the judge to the prosecutor. And you end up in the situation where a prosecutor may have a case and look at it and say, you know, I really don't think this is worth 30 days in the House of Corrections, so I'm not going to charge this particular section. And prosecutors have the discretion to do that. Or in the same sense, you may have a prosecutor who says, I'm going to push this section and force you to plea to a lesser charge, because the problem is if you go to trial, the consequences would be, you know, a 30-day minimum. In New Hampshire, we already have an endangering the welfare of a child statute. It has enumerated crimes within it. For example, it talks about how tattooing of a child constitutes endangering the welfare of a child. It talks about using children for commercial sex acts constitutes endangering the welfare of a minor. And I think that really what I would like to see personally is something to be added to the endangering the welfare of a child statute that says committing acts of domestic violence in the presence of children constitutes endangering the welfare of a minor. Keep it as a misdemeanor, but do it as a separate charge. So if you committed an act of domestic violence and you did it in front of a child, you could be convicted of both domestic violence, where you'd face up to a 12-month sentence, as well as endangering the welfare of a child, where again, you could be subject to up to a 12-month sentence for that. Those sentences could be run consecutive. You could face 24 months in the House Corrections, and that would all occur in circuit court.
If I could again pause
Yes.
you. So that's where I'm hanging up. I don't know about anyone else. Is about in the presence of a child. What does that mean for a police officer? Does that mean the child's in another room and hears it? Because I thought I heard testimony that they could hear the parents arguing. What is the risk of a victim actually bringing that into the child's presence by fleeing? Is it now in the child? Do you see what I mean?
I do.
It seems fraught with peril.
I actually think the definition in the bill is very good.
Okay.
It's page 1, lines 24 to 27. As used in this paragraph, in the presence of a child means the child was physically present at the location where the domestic violence occurred, or was in a location where the child could reasonably be expected to see or hear the acts constituting domestic violence, regardless of whether the child actually observed the specific incident of abuse.
So that just means at home. If the kid's at
Right.
home.
If they hear it through the wall, I think they're in the presence of a child. If they hear it through the door, I think they're in the presence of a child.
So aren't we really just making a crime of if you commit domestic violence and you have a child, because they're obviously 99.9% of the time going to be at home.
I think if you have a child and you're committing domestic violence,
it should be enhanced.
The chances are your child is witnessing that domestic violence and is going to impact that child.
I agree.
In the future, and it should in fact be a crime.
I just want to, if when we make laws, I want
Yeah.
them to be crystal clear what, and not kind of say, well, if in the presence, if you have, you know what I mean?
I think you're always going to have difficulties.
Yeah.
You know, when I look at this, I think in the presence of a child, well, what if you're on a FaceTime call and the child views it? Well, that wouldn't count because the child has to be physically present at the location. I don't think you can account for every scenario, but I think that this definition accounts for most of them. And I think it's a good definition, and I would carry that over into any amendments.
I think, as I said, I'm going to do a study. I'm not a study, a subcommittee, so we can get some things ironed out on it.
Yes.
I imagine Professor Shared over there would like to be a part of that, wouldn't you?
I missed what the chair said.
I said you would like to be part of the subcommittee. I think so too.
And in response to that, I would point out that Attorney Enders is a former student of mine.
You are now definitely on the subcommittee. Okay.
Actually, I
did
think
you have anything else you want to say? I know I kept interrupting you.
The only thing I would add was that Representative Scher was actually my advisor in law school.
Student advisor.
I was more than a student.
Wow. Wow. Yeah. His whole career arc is because of whether it turns out for good or ill. Questions from the committee? Okay, seeing none. As I said, I'll appoint a subcommittee, and I hope you'll work with them.
Yes, I'd be
I'll have
happy
the
to.
chair of that reach out.
Thank you.
Thank you. Next. Anyone else wishing to testify on this bill who has not done so? Seeing none, I hereby close the public hearing. What's next? Is it me? This very next one?
No,
What's the very next one?
relative to organized retail crime.
Well, let's just open it and see what's up. I hereby open the public hearing on House Bill 1670 and invite the sponsor to introduce the bill. Here comes a card.
Hello, I'm Susan DeRoy. I'm a brand new rep. This is my very first bill. So be kind, guys. But this is a very important bill. When I was running for rep, I had the privilege of sitting down and listening to loss prevention people in Stratford County. And boy, oh boy, what an awakening I had when I got to listen to them. We have a serious problem, a very serious problem. I am giving you an amendment to the original bill, and we're adding, I'm not going to go through my whole speech because I want the people behind me to tell you what's really happening. I'm just the introducer here. But this here adds, cargo theft and interstate commerce. So it's important that we have that in interstate theft, So I'm here to let you know that we all need to be paying attention to how much money we're losing in our state. We need our money, we need our taxes, and these gentlemen behind me are going to let you know. How's that?
Representative, could you fill out a card as well? Oh yeah, yeah. Thanks. Who's first? Joseph Morgano.
The button. There I go. Thank you, Chairman, distinguished members of the committee. Thank you for listening today to this important bill. My name is Joe Morganella. I'm a Dover resident, CEO of Quadrant Investigative and Protective Services, which is a local seacoast business, private investigations and security consulting. I'm a U.S. Air Force police veteran and a retired police sergeant from the town of Durham, New Hampshire, with 42 years of investigative and law enforcement experience. I'm prepared to give you a financial impact here in New Hampshire caused by organized retail crime. A national analysis breaks down the broader economic impact attributed to organized retail crime here in New Hampshire and the estimated losses to retail crime in New Hampshire in 2024. Total economic cost to the state was $898.7 million. Value of the goods stolen from several different large box retailers, $292.3 million. The year of 2024. Lost tax revenue that year, $59.8 million. And the cost to include shrinkage, insurance, wages, and lost output, that $292.3 million is only a part of the total cost to the state. The source on these figures is the U.S. Chamber of Commerce, and they do an important note, is that even though New Hampshire does not collect retail sales tax, that reduces the direct tax loss to our state compared to other states, but the business and consumer impacts remain huge in this state. Even beyond direct inventory loss, ORC, the organized retail crime, contributes to broader economic damage, lost jobs, and output. Retail theft impacts business profitability, which can reduce hiring, lead to layoffs, lower our total economic output, reduce wages and hours offered by local business. Higher business costs are incurred by retailers to combat organized crime, security systems and staffing, loss prevention technologies, insurance premiums. All of these are often passed on to the consumer through higher retail prices and basically a crime tax on our community. There's an impact on small and local retailers also because small businesses common throughout New Hampshire's downtown and shopping districts may be especially vulnerable because many of them may lack theft insurance. They have smaller margins, which make shrink much harder to absorb, and they're losing goods directly, which cuts into their operating capital and their profits. Organized retail and related theft ripple outward by price increases. Retailers tend to raise their prices to offset shrink losses, and this affects all shoppers. Store hours or service reductions. In areas with high theft incidents, some retailers may reduce their store hours, lock high theft items behind cases, or close underperforming locations, and these adjustments erode convenience and choice for our consumers. Tax base effects, even with no New Hampshire sales tax, lost business income and personal income taxes can directly reduce public revenue, and we don't want our large businesses leaving New Hampshire because they're losing more money here. Public safety and enforcement costs to address organized retail crime. Law enforcement and judicial resources must be deployed for investigations and prosecution. Retailers pay for private security and loss prevention, which doesn't show up in public budgets, but is a real economic cost to our local businesses. A recent New Hampshire legislative fiscal note on organized retail crime notes that enhanced penalties may affect workload for courts and corrections, though exact costs were deemed indeterminable. The bottom line is organized retail crime contributes to hundreds of millions in losses in New Hampshire each year, extending beyond stolen goods to broader economic, consumer, and public safety costs. And even if precise, organized retail crime data is hard to isolate. Thank you for your attention to that. Are there any questions?
Thank you. Having a college-age student who worked in a hold on a minute, I think my computer's talking to me. Who worked in retail during summer in college. He and I were both appalled at what was going on, and to what extent are retailers not pressing charges? He was told by his manager, just watch it go out the door, and nobody was stopping or confronting, and he witnessed people that he'd never seen before go to a car that with an out-of-state plate, and they were gone.
And there's no teeth in the bill right now to have anybody in loss prevention actually detain someone or hold someone on the premises, and my associate will speak more to that fact next. Thank you for your attention.
The chair calls Sean Michelinas.
Am I on? Well, thank you guys. I haven't been down to Concord in a moon or so. So my name is Sean Michelinas. I'm a former state rep. I was on this committee back in 2006, 2008. I've been very active in the community in general. I'm not a political, I'm a private citizen at this point. So this bill is like super, super important about, as well as you guys know that there's a lot of stuff that is going on in our communities that is on the ground level. Foot traffic. So now I'm going to address you guys properly. To answer your question is, he's absolutely right. There is no teeth behind anything. And how the law, the RSA is now, it's very faint. It hits low-level offenders. It doesn't capitalize on like the big people that are actually organizing and so on and so forth. So this bill is to fix that and fix those issues. But here I am, Chairman and sorry, this thing is like crazy. It's like, I feel like it's hit me right in the nose. I don't know. It's big enough. I don't know. Chairman, Vice Chairman, honorable members of the Criminal Justice and Public Safety Committee, thank you for the opportunity to appear before you today and your continued service to the people of New Hampshire. I appreciate you guys doing this. I am here to speak about the growing and costly threat of our communities, organized retail crime, or ORC. So if I say ORC, you know what it's about. This is not about petty shoplifting. This is about coordinated criminal networks that steal merchandise or cargo or resell stolen goods or undermine our economy in New Hampshire, our small businesses, our public safety, our big box stores, and our public safety across the Granite State. The financial and community impact, even without sales taxes, retail theft in New Hampshire costs our state nearly $900 million, which you heard in prior annually, including hundreds of millions in stolen merchandise, tens of millions in lost revenue in local governments, increased costs for security, insurance, law enforcement, lost wages, reduced hours, and lost jobs. Very, very important. Lost jobs. We can't have people losing their jobs and taking a workforce away. For many small and family-owned retailers, one organized theft ring could mean the difference between staying open or closing the doors. That's really important. We're all about business, about a small town feels. Public safety consequences. Organized retail crime is rarely a victim of crime. These enterprises are often linked to drug trafficking, fraud and identity theft, money laundering, violence, and intimidation of retail workers. And it's a lot easier now when people are doing drug money and so on and so forth and stealing items and selling it on the street to get money to finance these enterprises with the casinos, because that's an easy way to clean money. Money laundering, that's a huge issue, and in the Seacoast, and I know it's a big issue in Manchester as well. It's a huge issue in Manchester right now. Retail employees, many of those young people are seniors and are young people, are increasingly being placed in unsafe situations. Communities lose access to local businesses. Public trust endures, because the public trust is going away from this, because that's what's happening. You guys probably hear it in your own towns and cities where you guys are from. There is no longer just retail issue, it's a public safety issue in general. Why the current law falls short. Our existing statutes were designed for individual theft, not coordinated criminal networks. As a result, repeat offenders cycle through the system. Criminal organizations exploit low penalties. Law enforcement struggles to connect rings across jurisdictions because they're limited to their own jurisdiction, their own town. They can't really cross over. That's a huge problem with the bill right now. Not our bill, but the current law, sorry. Let's fix that. We would allow organized crime to flourish in other sectors of our economy. Retail should not be treated differently. How the proposed legislation corrects the problem, the proposed underrates RSA 637, that is the law behind this bill. Just kind of give you guys a heads up, it's in the language on the bill. Provide clear and effective tools to combat RLC. Stronger legislative definitions. ORC is now clearly defined as coordinated activity in two or more people, covering both retail stores, supply chain thefts, and so on and so forth. Aggravation of thefts. These incidents can be combined for over 180 days across multiple locations, including states, on this amendment. So we'll be able to go across border, like where we're so close to Maine. A lot of these people have been going with, say, to Walmart in Sanford, Maine, and then coming across into Somersworth, Rochester, and Portsmouth, stealing. Now we can correlate everything.
You do understand, though, we can't make a law that gives us extra jurisdictional powers to.
No, it isn't. But I'm going to be getting to that.
Oh, okay, all right.
Yeah, there's a warning. Targeted leaders of kingpins, enterprise leaders, and organized finance profit for ROC face Class B and Class A felonies. With these penalties, it's up to 25 years imprisonment on high-value theft. So if they correlate 10,000 or more, they can go up to 25 years. It's not limiting that the judge has to be a mandatory 25 years. It gives them the discretion to do so. And same with the penalties with the prosecutor as well. Extended jurisdiction precautions occur. The enterprise operates, transports, resells stolen goods, closing loopholes across the counties, including states. When we're talking about states, I know we can't legislate things going across the borders, but we can tell the local law enforcement or the state police to work with the federal agencies, which they in essence are obligated to do it. And on this, we can always strike this out of it, which is not a problem. It just takes a simple amendment to take it out. It's not a big deal. But the biggest thing is across counties, across cities, and across towns. That's the most important thing.
I believe our state police already is part of a task force.
All right, cool.
So I think, but we'll look into that.
Oh, yeah, perfect. Coordination with federal agency, law enforcement, and collaborate with the FBI, which obviously, if we strike that out, that's fine. I mean, the biggest thing is we know it's going to be amended. We always amend things like 50 million times. It gets frustrating. That's why I'm bald. from 2006. So let's get that straight. Non-emergent convictions, leaders and convictions do not merge for individual deaths, ensuring accountability for all levels of the enterprise. So it goes from the person committing the theft to the person that organizes it to the person that leads it. So it crosses the borders across the board, held everybody accountable for it. These changes directly target criminal networks, not individuals making the one-time mistakes, or protect the small businesses and communities that repeat thefts. Protecting New Hampshire way of life is the most important thing in this. New Hampshire is the place where small business can thrive, communities are safe, laws are fair but firm, accountability matters. Organized retail crime threatens all of that. If we fail to act, the cost will not be just be financial. It would be measured by loss of jobs, closed, storefronts, unsafe workplaces, and weakened public trust. So I'm going to do a quote, and then I'm going to close this up because, you guys at times are precious. I get it. I've been there, trust. Just kind of think of what I'm saying and just kind of do it. I'm going to leave a copy of this so you guys, I only have one copy, just so your secretary could just copy it and give it to you guys. I'd be very appreciative. If we only arrest the person carrying the bag, but never hold accountable a person giving the orders, the organized retail crime will continue to thrive. H. Bill 1670 fixes all that. In closing, addressing organized crime is not just being tough on crime, it's about being smart on crime. Protecting workers, supporting honest businesses, ensuring criminal enterprises do not profit at the expense of our communities and our taxpayers. I respectfully urge the committee to support these legislative updates to strengthen New Hampshire's response to organized retail crime, give law enforcement and prosecutors the tools that they need to protect our community. Thank you for your time and your consideration. Also, I want to let you know, New Hampshire Association of Chiefs of Police is in support of this. There is a couple adjustments that need to take place. The next speaker coming up, he's gonna speak on that, and one of the biggest thing is, like, the first section needs to mimic the law on the books now, because the purpose of this bill is to add on to that, not to replace it, because we want to make sure we got conspiracy in there and stuff like that. So there's a couple of wordings. So I mean, the biggest thing is he's probably going to suggest to push it off, but I mean, subcommittee.
This isn't really for you. This is for the sponsor. When you want an amendment, get the amendment and then bring it to the committee, and one of us can introduce the amendment. We just have way too many bills for us to start getting amendments. I'd probably mess it up. So it'd be better if you get what you want and then bring it to us. Thank you.
You have any questions?
Yes, sir.
In the past, this committee has heard of new high-tech crime.
Yep.
Gift cards,
Yep.
credit cards, skimmers, and
Yep.
that sort of thing.
Yep.
Would this bill address that sort of crime rather than just products?
I'm going to tell you, I mean, I talked to this, a gentleman out in the hallway, and he submitted a bill last year to kind of fix some of that, by my understanding. This bill is definitely just correcting the law on the books currently under organized retail crime, because you kind of have to keep them separated, in my opinion, because if you all link them all together, you know how that's going to go. It's going to open a lot of cracks in the legislation. If you keep them separated, have two different laws on the books, they'll be able to go to a different RSA to correspond with that. But when it comes to these organized crime syndicates, or what the stuff is going on, you really want to keep that separate, because I know for a fact firsthand, I've seen that with the cards. People would take off the tabs on the cards, and what they would do is they would pre-scan them, so soon a customer comes up, buys the card, swipes it up, puts the $25 for your grandkid or your kid. What ends up happening is the money goes straight to the person that stole the card. And guess what? Your grandkids not getting anything for Christmas or their birthday, because guess what? That money's gone. So, I mean, keeping it separate is good. And, you know, the biggest thing is that's something that, you know, more discussion probably would have to be on the lines that, you know, taking, you know, that type of crime, adding that and trying to turn it into organized crime, you know, retail crime, you know, just something we have to look at.
Yeah. Okay. Go ahead.
Yes, ma'am.
Sorry. Thank you for taking my question.
Yes, ma'am.
So when this happens, if you come back with your receipt and everything, are you the people reimbursed?
Actually, that's the biggest thing about this bill. That actually fixes that too, because you know, the current law as is, we'll say someone gets merchandise stolen, they can't really go after the criminal because there's nothing in there to saying that you can't. This bill actually fixes that. That actually puts a, you know, they can go after retribution or repayment back for whatever the lost is or whatever's stolen, and they'll be able to do a lot more than before. So it fixes a lot of things that the current law does not have.
Thank you. Thank you. No further questions. Thank you very much.
Thank you very much, guys.
Tom Persall.
Thank you, Mr. Chairman.
Thank you.
Vice Chairman Rhodes, members of the committee. For the record, my name is Tom Praisall from Demers, Praisall and Thomas, here representing the New Hampshire Retail Association. And I also want to thank the committee because you may recall last year you voted on legislation regarding gift cards, as the representative alluded to, that was passed on a voice vote, House, Senate, signed by the governor. And that's going to really strengthen our gift card fraud laws. So this committee isn't new. Organized retail crime is not new to this committee. You've seen it before, and you've done some great work so far. I also want to thank, you know, Representative DeRoy, because this is an important issue. You know, I attend these national retail conferences every year, and organized retail crime is a significant issue across the country. You see the articles in the paper, you see the news reports on TV. It's a real significant issue, and so this is a very important issue. However, I did want to raise some concerns that I noticed when I first read the bill. When I first saw the language, I was excited. You know, organized retail crime. This is a good bill. However, in the introduced version, it is a repeal and replace. And with the repeal and replace, you know, certainly sometimes you inadvertently, you know, remove parts of statute. So in this version, it repealed conspiracy to commit theft. And so essentially with this language, you would have made it harder, the burden harder for law enforcement and prosecutors to get someone for organized retail crime. And I understand there's another amendment, and I think, you know, speaking in the hall, there was talks of another amendment. However, I want to bring an amendment. And, you know, I think because it's an important issue, and my experience working on the gift card fraud bill was we held probably 10 to 12 meetings with the Attorney General's office, going through our statutes, right? Making sure the cross-references were appropriate, making sure that penalties over here didn't negate penalties over here, and just really making sure that it worked. And I think because this is such an important issue, what I would recommend for the committee to consider, and I have a copy of some language I drafted, is to turn this into a commission. You know, a number of states, when looking at organized retail crime, create a task force on organized retail crime, which you alluded, you know, I think our state police is involved in a national one. Yes. However, what I was thinking was if we created a study commission, right, like our version of the task force, I think it would be really helpful to bring all the stakeholders to the table. I'm talking the retail association, the grocers, the convenience stores, the county attorneys who prosecute these, the attorney general's office, the chiefs of police, the sheriffs. Bring these folks together and really do a deep dive into our current organized retail crime statutes and make sure that, you know, we can come up with something for next year, have it ready for introduction next year that really tackles the issue in a comprehensive way and isn't, you know, sort of piecemealed or, you know, we just don't want unintended consequences. So I kept the language of this study, you know, commission really broad, but I think I've always found bringing the stakeholders together, including the AG's office. I mean, They pointed out things to me on the gift card bill that I would have had no idea it was cross-referenced two statutes over, right? And so I think they're a really important person to have involved in these conversations. And, certainly I'm willing to work with the committee on, any amendments that are being floated and discussed. But, my feeling it was that I think we should really look at this more comprehensively and put together a package of something that can really make a real difference.
I think we would also need some real data, like how much money is this costing our businesses? How much is it costing? And I know that he gave us some pretty good data.
Sure.
But I'm not sure how comprehensive that was. And the Retail Association might be able to help contribute even more to that. I'm not sure.
Yeah, I'm happy to get you whatever information you need. I just think, it is a real problem. I think, the representative really
Yeah,
hit the
it
nail
is.
on the head. It's a significant issue. And as these criminals get smarter and more involved, things change.
And the
so-
bill, in my understanding, because I don't think this was brought up, isn't necessarily about the people with the shopping carts. We're talking about tractor trailers. We're talking about cut the bands on the back of the trail, all those things. And some of those, though, cross over into federal crimes. So I think I would prefer to look at it. And I do like the idea of a commission to look at it, because I don't want to start duplicating efforts that the feds are already expending money on.
Exactly.
There's a lot of
That's exactly what I was thinking.
Representative Share.
Yeah, in that vein, I'd be very curious to know what's going on around the country and what versions of organized retail crime statutes seem to be working and what versions seem not to be working. There's some language in here that suggests it's going to be very hard to prove this. So I'm not sure. I'd be curious what other states have been doing.
All right, I'm gonna.
And in
Go
that
ahead.
vein, I volunteer everybody but me for the committee.
Oh, I'm not going to do a study, a subcommittee on this. Go ahead. Yeah.
I just have a question. So what I believe you're telling us, in New Hampshire, there's some major truck or something of that nature that drives up to the back of the warehouse and unload your warehouse into a truck. This is what's in my mind right now. So if that's not what you're telling me, please break it down.
No, I think, there's so many different examples of how organized retail crime can be done. And sometimes it involves somebody going in or walking into the store, rummaging through the trash, pulling a receipt out that somebody had just bought a TV, threw the receipt on the side of the, in the trash can. Someone pulls that receipt out, goes in, grabs that same TV off the wall, and goes in and returns the TV they just took off the wall, right? There are also times where somebody walks into a Lowe's or a Home Depot, goes and picks up a generator, brings it to the front of the store and says, oh, I want to return this, but I don't have a receipt, so they get store credit. And so what this is doing is it's leaving the retailers really on the hook, because they can't prove, what's happening, even though they know it. Just like, the example that the chairman brought up as far as people stealing things and just running out the store. And the retail establishments are very concerned about the safety and well-being of their employees and their associates, and they don't want them. We don't know if that person who's stealing something has a knife or a gun or other dangerous weapon on them. And so they don't want them to be, a hero and step in front of them and possibly get harmed in the process of, just doing their job as an associate at Home Depot. So I think, there are all sorts of different facets of organized retail crime. And I think Representative Scher really hit the nail on the head. The beauty of looking at I want to be clear that creating a study commission is not intended to kick the can down the road and just put this off and say, okay, let's not do anything. The ability of a study commission involves exactly what you talked about. Having the ability to look at what other states have done and would have been proven effective in those states, and really taking those ideas and bringing them to New Hampshire. I mean, I think we see that so often with legislation. It's an idea that was born somewhere else, refined over time, and we're able to bring it here to the state. And I think that's really the goal. And I think we can do something with the list of names that I think I have, and I'm always happy to add to the list of anyone who's interested in this, but I think we could really come up with something comprehensive and be really at the forefront of this across the country.
And so our particular problem is that we've got a lot of commissions, and,
Sure.
and a lot of them are zombies. So before I propose a commission to the speaker, I want numbers to say, hey, this is how much we're bleeding here. So this commission is justified. It's not just another, we're going to get together and talk about it type of thing.
Yeah, and I will say, as far as becoming a zombie, nobody likes zombies.
No.
Halloween's a long ways away. But I had this, the way I drafted it, this commission would be repealed automatically in December.
Those are the best.
So
yeah.
it's a one-time look at it. And obviously, as the commission meets and goes through their work, if they think, hey, we should keep this going, that has to be brought through legislation. But I think it's more of a one-off, really force people to get together and get something done.
Okay. Representative Scher?
Just to be picky about it, I would strongly recommend that whatever language in a commission implementing a statute have the language that allows for electronic meetings, so that I think it's
Yeah.
much better to get easier to get stakeholders together.
Yeah.
If
This isn't about testimony. It's just about working together. So yes, I would agree with that. Yeah.
As a layman, it's difficult for me to fathom the amount of crime that takes place. Recently in the news, there was an article about a trailer load full of lobster that was stolen here, I think locally, but it was distributed all over the country. And I don't know how they got caught, and I don't know how they got it, but it's hard for me to fathom how that happens. Could you enlighten?
You know, I wish I could enlighten you as to how that happens. All I know is that if, the criminals who mastermind and commit these crimes really put their brain power to good use, I think that a lot of good could be done in this world.
Thank you for your testimony. Anyone else? Anyone else wishing to testify on this bill? Seeing none, could you and I talk? I'll shoot you an email, and we'll see what we can come up with on what you'd like to see happen with your bill. I know everyone's talking about doing stuff to your bill. It's your bill. I mean, it's really ours, but I respect you. Thank you very much. And I hereby close the public hearing. Next is mine. Jen, you've got to take over while I introduce this. $1367. Right. Yeah. Buzz, you're falling down.
I'm going to open the public hearing for House Bill 1367 and invite the representative to introduce his legislation.
Thank you, Representative Terry Roy, Rockingham 31. I'm here today to introduce House Bill 1367. And this is a bill that adds the offense of doxing and provides criminal and civil penalties and violations. I don't need to tell you guys about doxing and how horrible it is and what's happening to people. People are being harassed. People are being scared out of their homes, their jobs. We need to treat each other better. And unfortunately, we used to be able to just do that without laws because we knew better. Apparently, we don't anymore, and we need to put the brakes on. You can't watch the news without somebody being harassed, and this isn't about parties; it's happening to everybody. And so I'm going to go through it real quick and just tell you what the bill would do. But that's the reason for it. We have to take the steam out of this balloon that's going to pop in this country, and we can't fix the whole country, but we can fix, or at least try to fix, New Hampshire. So doxing, the definition given, it means the intentional publication of another person's personal identification information without their consent, with the intent, and that's the important part, the intent. As with all criminal bills, you have to have the mens rea, the intent to do the crime. So accidentally putting music or putting information out, or even intentionally, if you didn't intend to intimidate or harass somebody, it wouldn't rise to the level of that. And or cause substantial emotional distress or physical harm to a person or their immediate family. Pattern of harassment, another definition, it just includes 2 or more acts over a short period of time. Threatening the safety or targeting of their family, following, approaching, confronting, targeting their family, appearing near someone's home or work, a location where the target is, damaging their property. We give a definition of personal identification, what that means. It's information that can be used to identify or locate an individual, including but not limited to their home address, their phone number, their email address, their social security number, financial account information. We're seeing people right now get angry at somebody online and spend 2 weeks digging into this person, even going through their trash, getting their account information. And the next thing they know, everything about them, somebody's posted online as revenge. And it's in my mind, it's unacceptable. It's causing a huge, and it just leads to retaliation if it gets more and if it gets more. Publication means posting or disseminating information through any electronic or digital means, including the internet or social media. And the rest of those, it's a short bill. Doxing is a Class A, it's a misdemeanor. If it results in physical harm, if somebody actually gets hurt because you did this, or they suffer an economic loss exceeding $1,000, or it's part of a pattern of harassment, it becomes a Class B felony. And this goes on to describe which sections of law it changes. And with that, I'm willing to take questions. I was never his student.
This is such an opportunity.
Yeah, I walked
Wait,
into that. didn't I?
Representative Scheer, I did not recognize you to ask a question yet.
I was speaking to the vice chair that this is a great opportunity. May I ask some questions of the representative?
You're recognized to ask a question.
Thank you. I'm looking at line 22 on the first page. 21 and 22, it says, it does not include information that is lawfully made available from public record. And there's an or there. And then later, it suggests that even if it's lawfully available from a public record, if it's published with the intent of hurting them, threatening or so. Yeah, and we can talk about that, but the second thing is lines 28 on page 1 through line 3 on page 2. There's a ABC there. Are those conjunctive? That is it A, recklessly publishing another person's personal information, and B, and C? There's an and at the end of B, but not at the end of A. It would be clear that all 3 of those needed, as I read it, I think you mean all 3 of A, B, and C must be established. Is that right? I would just add another.
Or construction, LOLS probably should have caught that, but yes, I agree.
Add an and at the end of A.
Yeah, I agree.
Thank you, Representative.
Thank you.
Representative Roy, I actually have a question, but I might actually be asking, God help me, Representative Shear at the same time. So if may just give the example of what I'm talking about, and then we'll see if this is this, so I understand this. So if somebody posts on social media, and I fortunately don't have it, but that doesn't mean people don't take screenshots and send me what is there, right?
Yeah.
So if somebody posts something and says, you know, here you go, here's her home address, here's her phone number, and then there's like, you know, a picture, and then that, yes, right? And then that turns into harassment or any of these things. Now that person might not have been intending to say, here you go. They were just like, here you go. This, you know, there she is. And then these things happen. So is it a knowingly or purposefully, or is it just happened even though it wasn't your intention and now you're kind of.
The intent has to be established that the person doing the doxing, the posting, that was their intent to cause. And as Representative Scheer pointed out, they have to recklessly publish. That means without regard or proper concern for what they were doing. Publish another person's personal identifying information. They do so with the intent to threaten, intimidate, harass, or cause substantial emotional distress or physical harm to that person or their immediate family. And the publication creates a reasonable fear of harm and results in harm. So not only do they have to intend to do it, you actually have to say, I'm afraid. So just because they intended to do and did it, if it doesn't bother you, the crime hasn't been met. But if, again, I'm open to the committee's suggestions from anybody on wording changes that we think may or not be.
So we have to turn on our theatrics.
Yeah, yeah.
Thank you, Representative.
Just to I think you asked me the question too.
Oh, dear God. No.
I believe you said it.
I think she did.
Yeah. The interesting thing about lines 28 through 30 on page 1 and lines 1 through 3 on page 2 is there's two mental states. Recklessly publishing means that you were aware that there was a risk that by engaging in your conduct that this would happen, and you went ahead and engaged in that conduct anyway. That's what recklessly means. Mm-hmm. Whereas does so with the intent to threaten. And in addition to acting recklessly in the publication, you need to establish a more difficult mental state, intending to hurt somebody.
So it's a relatively high bar that I'm setting here. So it's only going to be the egregious people who basically out themselves because they can't help themselves and say, you know, like to your point, here you go, see what you can do to her. Okay, so we've established reckless and intent right there. So it's but again, anyone has any questions? I don't want to eat any more of our time.
Hold on, because hands went up. You didn't have a question also? Okay.
You guys know where I live if you have a question.
Question. Thank you, Madam Chair. Thank you for taking my question, Representative Roy. Okay. I'm just looking at this. Lawfully made available from public records or as a part of a legitimate news report. What about something online like white pages?
So if it's available, if they came, well, what did it say? I'm sorry. Read again what you were asking me. The publicly available. That's not publicly available. You pay to get that, I believe. But basically, white pages, a lot of white pages is just the old phone book. Now it's electronic, so that is publicly available information. So I think you would have to meet this, you'd have to go a little bit deeper than that. If someone went to the extent to not have their, because you can have your number private and your address not on there. But yeah, and again, we have to get back to intent as well. It's not just the fact that they found it; it's that they said he lives here in case no one else wants to pay for white pages.
Here's a picture of the house.
Yeah, yeah, and I worry about also with children. This is happening in high school a lot, and kids are killing themselves over some of this.
Hold on one second, Representative Prue. Representative, you might want to flip your name tag over unless you want to be Rep Morency today, but Representative Prue.
Even though it's found publicly, it may have been just a small blurb, publicly little news thing, but if somebody takes that information and tries to do it with bad intent, I don't think it really matters where the source comes from. It's what they're doing with that information. So
Mhm.
I think that kind of inhibits some of this. They can always say, well, I saw it on the news, but I took it and I used it in a non-well-meaning manner. So just a thought.
Yeah, we could look at that language to see if it needs to be tightened up a little bit. What I want to avoid is there being a story in the news about someone and someone just shares it and said, well, you even did that to embarrass me and that made me feel bad. Well, yeah, that life is tough sometimes. But if you go to extents to actually getting someone's information and you had to dig it up a little bit, so I'll look at that. We can work on that. Yeah, no, it's good feedback.
Any other questions? We're good. All right. Thank you, Representative. You're off the hook.
Thanks. I have another bill. Is it next or no?
We'll have to ask the clerk.
No? Okay.
The real rock star of this committee right there. Representative Guyson? Here you go, sweet. I don't know where I don't know where to.
Thank you, Madam Chair. Thank you, committee. I'm going to be very brief because I know you guys have had a long few days. This is a very real issue, and I know that many of you here are more intelligent than I am on how this law should be written, but I really do think that you need to focus and tailor on this one. This is actually happening, and this actually happened to me last year. Last year, as an elected representative, as a freshman, I voted on a contentious bill, and we got threats on our household. Somebody actually posted that they were going to, quote, board the place up and burn it down. My wife works from home. I was concerned about going to vote in the next election, or in the next day here, because I was concerned about leaving my house. A job that pays me $100 a year cost me a security system, because after that threat was made, somebody else went on and said, oh, well, here's the address. This is on a social media forum. Somebody had taken my address, which is public record, and put it on a post where somebody was threatening to burn my house down with my family in it. So this is really happening in real time. And he had mentioned, the previous speaker had mentioned, threats of schools, threats on children committing suicide. These things are actually happening. And by defining that you cannot share personal information for criminal intent, for threatening, for intimidation, we need to make this illegal. We need to make this a backable law, because it doesn't take much to figure out what bus stops people's children are going to, what retirement facilities their parents are in, and you can't secure everything all the time. So these threats are very real, and we need a mechanism to protect the people's privacy, safety, while also, acting prudently. So that is my situation on this. Thank you.
You good? Okay. Thank you very much. Anybody else? Seeing nobody, is there anybody here that wishes to testify on this bill that has not turned in a pink card? Seeing none, I will close the public hearing for House Bill 1367.
I hereby open the public hearing on House Bill 1139 and invite the sponsor to introduce their bill. You've been here all day, and I feel so bad.
Good afternoon. For the record, my name is Deborah Elward, and I represent Merrimack District 5, which is Andover, Danbury, Hill, Salisbury, and Webster. This is a simple bill relating to criminal trespass. The purpose of this bill is to clarify and harmonize the definition of secured premises under 635-2 with the posting requirements set forth in 635-4. By expressly recognizing that private property which is properly posted on or within its boundaries constitutes secured premises for the purpose of the criminal trespass statute. The bill is intended to eliminate ambiguity regarding notice, promote consistent application of the law by courts and law enforcement, and to ensure that individuals are not subject to criminal liability absent clear, reasonable notice that entry onto private property is restricted. In doing so, the bill seeks to balance the legitimate interest of landowners in protecting private property with due process protections and clarity for members of the public regarding lawful access. The state's interest is to ensure, the state has a fundamental interest in ensuring that criminal trespass statutes are applied clearly, narrowly, and fairly. This bill protects due process and prevents overcriminalization. We want to make sure that citizens are not threatened with arrest, incited, or chilled from lawful conduct based on ambiguous property claims. The bill provides clear standards for law enforcement. It reinforces due process by preventing criminalization of conduct that is lawful or subject to unresolved civil rights. The state has a strong interest in providing clear statutory guidance so officers can distinguish lawful access from unlawful entry, avoid improper arrests or warnings, and apply the law consistently statewide. Furthermore, this bill prevents misuse of criminal law in civil property disputes. So the state has an interest in preventing escalation of neighborhood disputes into criminal allegations, selective or retaliatory invocation of criminal trespass, law enforcement being placed in the middle of unresolved civil claims. The bill narrows and clarifies secured premises as on or within a private property boundary. That removes ambiguity about misleading postings, and it is something the trier of fact may evaluate in disputed cases. In 635-2, Roman 5, it currently reads, or in a you post your property, by posting every 100 yards, or in a manner reasonably likely to come to the attention of intruders. That's not clear and straightforward. It's somewhat subjective. What I think is reasonably likely to come to my attention may not be the same for everyone. But the remaining language provides sufficient objective guidance. This bill separates legitimate exclusion from misleading appearance of exclusion. The bill does not create a new crime. It does not increase penalties. It does not expand criminal liability. It does not mandate enforcement actions, and it does not change sentencing ranges. So I took issue with the fiscal note, and to save time, I prepared a handout that explains my concerns. The bill does not trigger any of the LBA's cost mechanisms. It overstates cost, and it should not be considered for objection as an objection to the bill. So in the downtime, I had an occasion to talk with two groups, and I will let them explain their suggested amendments, which I am in full agreement with. So I would like to defer or ask if there's any questions.
Did you consult with anyone in law enforcement? Did you get input from them on this as far as their ability to handle these new changes or what they thought about them?
No, I wasn't contacted, and I didn't contact them.
Okay.
It will involve very minor training changes, I think, in understanding, and that shouldn't trigger additional expense or appropriations.
I wasn't concerned about that as much as sometimes the perspective they can give you from being the person who actually has to make an arrest based on a new definition. They can say, "Did you think of this?" And you might not have thought.
I actually had occasion to talk to a trooper out in the hallway.
Yeah, they're wandering around. They're good to grab.
And I asked him exactly that, and he reviewed my bill.
Mm-hmm.
And he gave me excellent feedback. He agreed with me that that phrase was ambiguous and that it made it harder to ascertain out in the field what was going on.
So you did consult with law enforcement?
I
see?
did.
There you go.
Meanwhile, I'm a retired private investigator of 20 years and detective agency owner. And we lived or died by no trespass signs out in the field doing surveillance.
Yeah.
And we had to be very, very careful where we were, because if we thought we were on public property but ventured onto private property, any evidence we obtained might not have been used in court.
Yeah.
So I've been keenly aware of trespass statutes in Virginia, DC, and New Hampshire doing that kind of work.
Great. Okay. Thank you. If you have an amendment that you've come up, I would add the same thing I told everyone else.
Yes.
Once you get it where you want it, have it done by OLS and you bring it to us. And
Perfect.
Thank you.
Thank you. All of you.
Questions?
Oh, yeah, questions.
See you none? Thanks. The chair calls Representative Fract.
Thank you, Mr. Chair. First, I would like to apologize to you and the committee for the confusion at the very beginning of this session. No, it wasn't. I thought that this bill was up first. I don't know why. I could blame it on my colleague, Ms. Aylworth, but I won't. In any event, Mr. Chair, thank you, and honorable members of the Criminal Justice and Public Safety Committee. For the record, my name is David Fract, representing Grafton 16, the town of Enfield. As co-sponsor of HB 1139, I wish to lend bipartisan support for this important measure. Representative Aylward has already spoken about the need for this bill, what it does and does not do, and therefore anything I say would be redundant. So I'm going to end it right here. It's been a long day. I will take questions.
Thank you very much. Alex Holobinko. The chair, am I maybe not saying it right? Is anyone else named Alex here? Huh?
Do you want me to see if they're in the hall?
If you want. Yeah, I'm gonna.
See if they're in the hall just because of.
Jason Stock.
Well, good afternoon. For the record, my name's Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. I don't have the opportunity to come before this committee frequently, so I may be a fresh new face for you. But we have an interest in this bill because our members own land, some of them post land. Our membership, I'd say conservatively owns or manages about 1 million acres across the state. And they manage it principally for forest products, but also for wildlife habitat and other uses. We also represent the state's forest products industry. And I appreciate the opportunity to come and speak before you today. I'm coming in opposition to the bill, and I was one of the two groups that the sponsor had mentioned has been talking to about this, and we may be able to, I think we're able to kind of get to a point here that we can bring an amendment forward. Briefly, and I know it's been a long day for you, lines 24 through 27 was really the heartburn for us initially on this bill, where it would obligate landowners to provide make reasonable efforts to provide access or alternative routes. Picture a situation where you own a piece of land, there's a pond, people cross your property, there's a little foot trail that goes to the pond, you're fine with it, you don't have a problem, you don't post your property. You go to do a timber sale and you say, all right, I'm going to have heavy equipment out there, they're going to be cutting trees down, I'm going to post this property, while my timber sale is occurring. We don't want to set up a scenario or a situation where now it's incumbent on me to provide a reasonable alternative and have to search around and find that alternative.
That could be impossible. It just occurred to me, my property is surrounded by state park. I can't provide. Yeah.
So that was. Thank you. The other piece is we felt that line 20, clearly communicating that the property is private and access is restricted. We felt that was in fact redundant. If you look up above in the existing language, you're already, to legally post property, you're already obligated to put your name and address on it. So I would say that would really lend itself to saying, hey, this is private property. Here's who it is, and here's their address. And then lastly, I would say on line 18, where you look at this is to clearly visible for it to be kind of legally posted, it needs to be clearly visible from any public road or commonly used access point. Picture a piece of property, a square, it has frontage on one side of it, you post the entire parcel. Well, 3 of your 4 boundaries are not visible from the road. So I think we are able to, I think we, in the sponsor indicated that there's a willingness to remove that paragraph 4, remove lines A and C, and just clarify that if you're going to post, you need to post, the postings need to occur within your boundaries, which I always kind of thought was the law already. I can't put posted signs on someone else's property, but we can move that, add that point of clarity, and I think we're pretty close there. I still need to run this by one of my partners in crime, Rob Johnson from the Farm Bureau. He's out of town this week, but I'll run it by him in my policy committee. But I think we're getting close. But I appreciate your indulgence this afternoon, and thank you for your time. I'm happy to try and answer any questions.
As this isn't an early bill, I think I can give you a few weeks to
thank you.
to coordinate. Keep in mind the intent, as far as I can tell, and I understand you represent lots of acres of property, but it's all kind of up there, and I think the intent is more smaller local trespasses versus on timber. So when you guys are working on it, I know you're interested in those are legitimate because it's difficult to manage property. You're not out there. It's very difficult. So I just want to make sure that if we come to a conclusion, it covers both of us.
Thank you, and I will endeavor to do that again.
And I remember you from the purple paint.
Purple paint.
Yes.
Trail cameras.
Yeah. Thank you. It was good to see you again.
I still have the scars back there.
Yeah.
Thank you.
Those never passed, I don't think. Any questions? Not seeing none. Thanks.
Thank you.
Chair calls Sarah Burt Cohen.
Good afternoon, everyone. My name is Sarah Burke Cohen, and I represent the New Hampshire Municipal Association. I am the other organization that the sponsor spoke with. At this point, as drafted, NHMA is opposed to this bill. Simply we are opposed because changing place to private property takes out where place can be defined as public property or private property. It takes that out. Now, I know some of you are probably thinking, wait a minute, it's public property, people can enter it. There are some public property that need to be, are non-public by virtue of maybe a safety issue. Maybe it's going behind the desk. It's not automatically allowed at town hall for you to just saunter behind the desk if the clerk or tax collector is counting money, right? And so there are places like that, including property in itself, land we're talking about, could be a closed landfill, right? That is public, potentially owned by a city or municipality, is closed because of safety concerns. And so it needs to be posted as, please don't trespass on this. We don't want you to get sucked down into the
Now that we've invited 1 million First Amendment audits,
Right.
Are you close with the sponsor on it?
So we have spoken with the sponsor, and like I said, NHMA is opposed to it really for changing that place to private property. And if it goes back to place from private property, that would be something that we again, I'm going to mirror what my colleague who was just up here said. Obviously, I checked with my team, but that would be something that we would be amenable to and probably withdraw our opposition.
Questions for the NHA? None? Okay, thank you.
Wonderful. Thank you very much.
Anyone else wishing to testify on this bill? Seeing none, close the public hearing. With that, I open the public hearing. How many do you have on this? No cards, so we're just going to go through it. I open a public hearing on HB 1289 regarding the use of unmanned aircraft. And I invite the sponsor to come up. What's that?
His card's coming.
He is, okay.
Yep.
Is introduced. Yeah. I'm going to open a recess. Well, no, some other people came all the way here to, yeah, why don't just, do you want to just real quick, just because I know people came to testify why we don't need it, and yeah, and the sponsor didn't come, so. I only want to open it to give them a venue to testify. Yeah. Go ahead.
Thank you. I also just wanted to state, so people don't think I'm on my phone, my iPad died, so I'm just taking the notes on my phone.
I don't understand how you're doing that with Instagram. Oh.
Good afternoon, Mr. Chairman, members of the committee. For the record, I am Representative Jennifer Rhodes, representing Cheshire County District 17, Winchester, Richmond, Swansea, Troy, and Fitzwilliam. And I am here as a courtesy to just give the title of House Bill 1289. The sponsor, my understanding, is not here, but we do have some fine people behind us that would like to speak on this bill. So with that, I would ask that you direct all questions to the people behind me.
Thank you. So who we got here? Okay, so we'll start with Tricia. The chair calls Tricia Lambert. Did you folks come together? Did you want to testify together, or do you have all? Yeah, sure. Come on all up. Yeah, yeah. Well, that's actually a love seat that we. Yeah.
We had that last year.
Okay. If you could just identify yourself and tell us what you want.
Yes, I think it's on now. Good afternoon. My name's Chris Ball. I'm representing the Department of Safety here on behalf of State Police as well. And just to give you a little context to my background, I am one of the troopers that is assigned to our drone unit to help manage the functions of our State Police drone unit. Lieutenant Chris Storm, couldn't be here just because he is testifying over the Senate this afternoon, so he asked me to come fill in for his place. So I'll try to do as good a job as he does. But I can let you introduce as well, Tricia.
My name is Tricia Lambert, and I'm the administrator for the Bureau of Aeronautics at the New Hampshire Department of Transportation. And just a little background: we're the under SA 422, we're the liaison to the FAA, and we deal with all regulatory issues relating to aviation in the state.
And before you start, if I may, I could be having deja vu, but I'm pretty sure I wrote a bill, and we took care of all of this already. I'm sure you're going to tell us about why this. It seems to me everything I read, I thought we already took care of. But go ahead. Just last year, that's why I was wishing Lieutenant Storm was here, because he would have refreshed our memories.
Absolutely. He wished he could be here too. But essentially, yes, just a couple points we wanted to make on behalf of Department of Safety is that, one, a statute does already exist that was codified and now is in law given this past January regarding nefarious drone usage in New Hampshire. We have just 2 points to make is that, one, we feel that law already covers what's being introduced in this bill. And secondly, some of the language in the proposed bill kind of leans towards the state regulating federal airspace, which leads to some legal complications as far as if it were to be introduced or added to the rest of our current law. And Tricia may be able to speak a little bit more on what consequences might stem from that kind of.
So in the section that talks about it says basically that it would be for an unmanned, sorry, I gotta wear my glasses. The unlawful operation, a person is guilty of a Class A misdemeanor when a person knowingly uses a small unmanned aircraft system to enter onto a land or into the airspace above. So what that would mean is that you would, if somebody flies near your house, that would be a violation. One, I think it'd be very difficult for us to determine what they were doing. But it restricts the airspace. You're essentially restricting certain airspace, which is left to the sovereignty, to FAA, the federal, that everybody has the right to transit that airspace.
Is there a height where it becomes federal and stops being mine?
It's a really good question. FAA will tell you they go to the grass blades, but we know that there's areas in there that haven't quite been defined, and that's certainly been discussed many times. But as it is right now, they own the air for the people. So
I believe that's Representative Newman's fault, but okay.
if I may just
please, I mentioned my name. He has to.
The only reason he says that is I was an air traffic control supervisor for over 20 years.
Oh yeah.
But I do have a question.
Yeah, go ahead.
Who do you, when you deal with the FAA, do you deal with somebody at the New England region down in Burlington? Is that who you deal with?
We sure do. So there's different arms of FAA. We deal with the Flight Standard District Office, which is up in Portland. But when our office is responsible for the infrastructure development of all the airports in the state, so we deal with Burlington, the Burlington Airports office that's down there.
Thank you.
And we interrupted you. Please go on if you had.
Just a clarification, because a lot of this comes up in other bills that I testify on. So when people are trying to restrict things, there is one thing that the state can do, because the state owns the land, is that someone can restrict somebody from taking off from your property. So if you have, like state parks, for example, they have a permitting process. They don't want people departing without a permit or without approval. But if you have an adjacent property next door, someone could take off and fly over the state park. So there is some ability for the state. It's usually the restriction is taking off or landing onto private property.
The drone I got 2 Christmases ago that as soon as I turned it on, it flew into Bear Brook State Park and never came back. I didn't break the law.
Somebody got
Other
a,
than
somebody got a
maybe
new
littering or
drone,
something.
albeit broke.
Point out the
maybe.
chair has the Fifth Amendment right here.
Yeah, I was, yeah, I'm not going to deal with drones anymore after that incident. It was very exciting.
You're
as
not
it
alone.
flew away.
You're not alone.
Okay.
With your dreams.
Yes, yes. I had big plans for that drone. Representative LaSalle.
Thank you for taking my question. I have a personal instance, and I'm just wondering how that would fit into this. My wife and I happen to live in the town of Litchfield, directly across Route 3A from a school property. We have a front porch on our house. I was sitting on the front porch one weekend morning. It was early in the morning, just very calm. Nobody's across the street or anything. And something caught my eye. So I look over, and probably 50 yards from where I was, I noticed there was a drone, and it was looking right at me, or I assumed it was. It was stationary. So I looked at the drone, I pointed at it, and immediately, poof, it flew away.
Aliens.
Now, it was on private property. As far as I know, I had my shirt on, so there was nothing nefarious about it. Yeah, thank goodness. It's not going to show up on Facebook. But I assume there was nothing illegal about that, or would there be?
I'm not the judge and jury on this, but you're near Manchester Airport, correct? You're right, near.
Yes, but it didn't go very high. But
Okay.
yes, we are close to the Manchester
Right.
Airport, 8 miles.
So there is a grid system around Manchester Airport specifically, and I think most people know that drones can't operate near airports. It depends, there's different levels. Some area there are quadrants. So some quadrants go to the ground, and some quadrants have a 200 or 400 feet buffer. It depends. Not knowing exactly where this is, there may have been a violation that way. However, you can fly there with permission. You can get waivers from the FAA. So, for example, if we're going down to do a road, to survey a road, Jason in my office would go and get the permission from FAA to go fly there. So there are drones that operate there legally, not knowing this particular circumstance or who this person was, but just that would be my concern, is it being so close to the airport.
It didn't get very high, and it
Yeah.
never got above tree top level.
Right.
And it didn't look to be very big. And I see all the time people post pictures of, like, drones taking pictures of the Holly Jolly Journey, if you're familiar with it. It's a light show down there.
Oh.
It's very close. And that's closer to the airport than me. But with respect to this particular bill, my particular instance wouldn't be a problem.
I'm gonna.
I guess,
State
I guess
policy
my opinion would be potentially not, no. As long as the airspace they were flying in was not controlled and they were allowed to fly in the airspace, that would be okay. The other prong of it is looking at whether or not your, I guess, privacy was violated, correct? So if you were in a private space, potentially, but if you're outside your front porch in a public area, is viewable to like a public street, then perhaps not. So my initial inclination is to say no, probably not.
And if I recall, I talked to or exchanged an email with the sponsor, and I understood what he was trying to do, but I think everything he was trying to do is covered in different statutes. The privacy part is in the privacy statutes, not in the drone statutes. You violate the privacy statutes with a drone, it's still a violation of someone's privacy. It doesn't have to be specifically listed as a drone crime, right? Is that
Correct. That is our opinion as well.
Yeah. Okay. Thank you. Representative Scheer.
I just looked at the bill that we passed at last year, and this adds the reasonable expectation of privacy of individuals who own the property. So it's in addition to what we passed last year. Last year talked about basically, we were worried about interfering with, drones over prisons and jails and things. So it's a more narrow version of this, and this relates to people's reasonable expectation of privacy. So it may actually cover, it may.
Don't we have peeping Tom statutes already?
Yeah, this is more specific in that it
It's
covers
drones.
drones.
Yeah, but I hesitate to want to assign it to every new piece of technology. Either you're violating someone's privacy, regardless of what you're doing it with, and unless we need to actually make it be. And it's my understanding they can be charged regardless of what tool they use to violate privacy. If
That's
they
correct.
violate the privacy or trespass or whatever. Yeah. Okay. All right. No further questions. Thank you very much for enlightening us. And
Thank you for the time.
it's always hazardous because your subject matter is very interesting. So everybody starts thinking, hey, I want to know about this while you're here.
Happy to answer any questions.
Thanks.
Thank you.
Thank you.
Thank you. The chair calls Neil Kirk.
For the record, I want to point out that the Honorable Neil Kirk and I co-authored a law review article together. He's not a former student of mine, but he's a co-author.
Good afternoon, Mr. Chairman and members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I'm representing myself. This is a very important bill, and I believe it expands on the existing protections of privacy that our statutes provide. It's my understanding right now that anyone with a drone can fly that drone with the appropriate cameras over anybody's property and take pictures of anything he or she wishes to do, including you sunbathing in your backyard, and it is not a violation. Now, depending on what they might do with that information, there may be a problem. If people want to find out what physical property you own, your lawn chairs, your shed, and so forth, perfectly legitimate now. And the reason for this is that drones and their cameras are something relatively new. I think this is an important bill because it puts into law the protections that I think most of us really would like to have. I don't want somebody flying over my house taking pictures of me doing whatever I'm doing in my backyard. My backyard's private. I've got fences all around and hedges, and I don't want people going around knowing that that I'm doing something in my yard or that I have a particular physical facility, property, movable or otherwise, in my backyard. I certainly don't want my family, my young children, who might be playing in various states of undress in the backyard, photographed. And I certainly don't want any of these things put on the web or otherwise made available. It's my understanding that, without going into the detail about what you can do with the material, there's nothing that prevents somebody with a drone from doing this. Now, it's possible that some of our stalking laws might apply to a drone situation if the drone was being used for stalking purposes, however that might be defined. But this bill is important because it's very specific and talks about the expectation of privacy. If something like this isn't law, I suspect there are going to be a lot more people shooting a lot more drones out of the sky. I just don't cotton to that idea. And I think the bill tries to do what most of us expect the law to be. Nobody can do that. You can't come and take pictures of whatever I'm doing. Now, there are some problems with this bill, and there are various ways to deal with them. For example, the folks who were speaking to you before were talking about what the FAA requires, and they're correct. States can't regulate drones, but we can regulate what drones do. For example, we can put in regulations with respect to drones and privacy and voyeurism. We can put in statutes with respect to drones and trespass, or harassment and stalking. But what we can't do is to say you can't fly your drone over my place. So every time you're sitting on your front porch and that drone is out there, you have no clue whether he's out there legitimately just hanging around or whether he's taking a photograph of you. And you'll never know because, as you said, he's zipped away. You can solve the problem that the prior testimony gave to you by eliminating on lines 4 and 5 the words, "to enter on the land or in the airspace above the lands of any other person without permission or otherwise committed trespass in order." If you eliminate those, the FAA objection goes away because now the only thing you're regulating is privacy. The lines 8 through 10 are extremely important. What they're saying basically is, if in fact you're taking pictures, you can't sell them, you can't broadcast them, you can't make them public, or else you commit a Class B felony. And I think this is what most folks in New Hampshire would want.
I think you're absolutely right, but I still need to understand, can we do this from the FAA standpoint? Because we're saying, we're not saying you can't fly, but you can't take a picture.
Correct.
Or is that
That
crossing
is
the line?
something the
Yeah.
states have the power to regulate. And that's, many states do this. Florida has a very
they do?
exceptional example of
I'll
this
look
kind
that
of
up.
thing.
Have you contacted or been in contact with the sponsor of this bill?
No, I will tell you that Senator Reardon has a bill that deals with the same subject before the Senate.
Okay.
And I testified on that bill.
Yeah.
And eventually, I suspect that will come to the House.
Okay.
But it may not. The Senate is
Yeah.
dances to its own tune.
If the sponsor reaches out and we discuss but we don't have the bandwidth to chase down. He needs to get his own amendments. In other words, unless a committee member wishes to do so.
Okay.
But I do want to research. I am interested enough that I do want to research what you said about Florida and the abilities.
I have prepared an amendment for this bill that brings it into compliance with the FAA and deals with a lot of the problems that
Okay.
are in this bill.
Yeah, that'd be great if we could take a look at that.
I'm more than willing to offer that amendment at the appropriate time.
Yeah.
I've looked at the 644:9, which is a violation of privacy statute. That is really focused on sexual activity.
Yeah.
It wouldn't. This is much broader than that, in that it really does. That is a very narrowly tailored bill, and this covers a broader and. I agree, more important area.
We have to be careful because it also covers in other words, right now, and this is an objection I have, and I think I'm pretty sure I put a bill in this. Insurance companies will randomly fly over your house and look at your roof, and if they say, you know what, that roof's aged a little bit, they will jack your insurance company up. I mean, your insurance rate up based on the age of your roof, and they're using drones to do these type of things now, and I don't think that's okay either.
That would, and I.
But
would
can
defer
we
to
do anything
Representative-
about it is what I need to be
Yeah,
sure
I
of.
would defer to honorable representative, but that would need additional language in this bill.
Yeah.
As I read it.
Some of the other issues, paragraph A on line 11 exempts all sorts of things from this bill and does it in a way that allows just about every business and every government agency to do whatever they want as long as they're undertaking some legitimate purpose, and businesses have legitimate purposes such as this chairman just mentioned. And it's so broad that it basically eviscerates the bill, so that in effect the bill only applies to individuals, and that I think is not suitable. So I have some language to deal with that. The other thing, of course, is if in fact there are exemptions for government, which there must be for law enforcement, firefighters, and so forth, the question arises, what do they do with the material once they have it? The case is over. Are we going to allow the state to accumulate these kinds of files in law enforcement or fire department forever and ever, so that in the course of a number of years there's going to be a database available to the state of what every single person in this state was doing at some particular time? So there are ways to deal with that, and the amendment does that. There's no exemption in here for news media, and that's a serious issue. The amendment deals with that. If the chairman plans to send this to us, a subcommittee, the subcommittee could work off the amendment that I have, and it may be a helpful starting place. Would you like a copy now? I'll give them, I haven't, well, no, yeah, I have one more. That completes my testimony, Mr. Chairman. I'd be pleased to answer any questions or help you out in any other way that you see fit.
I appreciate it. If I could, if you have a card or something so I could contact you if I have any questions, or is that on here?
Well, no.
No?
I will give Representative Scher
There you go.
personal information, and he can pass it on to you.
Thank you. I'd appreciate that. Because I need some time. I need that. Yeah, be careful. We're doing law now. I just want some time to digest all of this and look at it before I decide which way we'll go with it. Any questions? Any of the Honorable Mr. Kurt? No? Seeing none? Thank you for coming.
Thank you, Mr. Chairman.
Anyone else wishing to testify on this bill? Seeing none, I hereby close the public hearing. After you read that, if you could, someone let me know what you think about that amendment. What's up next? 9 again. Okay.
I am opening the public hearing for House Bill 1464 and welcome the sponsor to introduce his legislation.
Thank you, Representative Terry Roy, Rockingham 31. I'm going to, as quick as I can, this is a very, it looks like a big bill, but it's not. It just adds a definition to our current statutes. And it adds under discrimination or protected class when someone's committing a crime like that, harassment, violence based on political affiliation or opinion. Too often, again, I'm going back to what I said last time, we're all of a sudden going after people and hurting people and intimidating people, and this is not one party or the other, it's the entire country based on their political beliefs and what they express, or which party they might. These are things that we used to celebrate in this country, and be, I'm proud, I'm this, I'm that, that's great, and we'll debate. Now, not so much. Now people are being killed. Let's be frank. And before it gets to that level, we need to stop it when it's just harassing, before it becomes murders. And that's what this bill does. It adds that as a protected class. You can't discriminate against someone. I can't rent an apartment, have an apartment building, and say, because right now I could do this. I'm not renting to you because you're a Democrat. I only rent to Republicans. That's legal. That should not be legal. Because that's part of the person's free speech and it's who they are. And I understand that free speech is only designed to be protected from the government, but it's who we are as a country. It's not just about that. It's about who we are as a people. We should not be able to discriminate lawfully against people because of what they believe. And that is, in political discourse is really at the end of the day, it's the heart of this country. It's how we get things done. It's how we interact. It's how we talk. It's how we make laws. and when you can discriminate against someone and isolate them out of society or withhold things from them because of who or what they believe, and they become silenced, all that's left is violence, and that's what we're seeing happen. So I'm happy to take questions. I think the bill really speaks for itself, but
Okay. Chairman Roy.
Yes,
It
sir.
says, or that person's political affiliation or opinion. Now, is that specifically a political opinion or any opinion about anything?
political opinion, their political affiliation or political opinion.
Okay.
Yeah, because it could be like you don't like hot dogs, and I don't rent to people who don't like hot dogs. So, yeah, no, yeah,
May I ask a
yeah,
follow-up?
exactly.
Could what if someone had a different opinion about history like that, just a different opinion about a historical event? Would that cover?
I don't think it would.
Would that
That's-
add value if we were to add something like that into this as well?
I don't know. I think if we go too far afield, I think I know what you're saying. This happened. Well, that's not how it happened. Here's a good example: the big political switch people debate, like, well, this year the Democrats became Republicans, and this year Democrats. I don't think we can cover everything now. It'd be great if we could, but I think it may end up being political. I don't know if we can define it that much. Some things you almost have to leave for the court to define. I don't know that we could get that granular. I'm not sure.
Okay.
But I'd be open to suggestions.
Thank you, sir.
A lot of questions on this one.
Representative Shear?
To follow up on the previous question, the one that falls in a gray area is Holocaust denier. Is that a political opinion? I know there's not an answer to that, but that's the gray area I'll think about.
Yeah,
if
and I
there's any
wonder
way to-
if there's a way to.
Yeah, I'll think if I can come up with anything.
I think it's the same. Yeah, it's history. Yeah. I don't know
But
that
it's
you.
perceived as a political opinion.
But should it be? Or should it be perceived as a lack of education or intelligence? I mean, we can't.
I know.
Yeah. In other words, where'd you go to school? It's okay if you weren't here. Okay, let me know if you come up with something. I can't tell you. Sorry.
So we can't discriminate on stupidity either way around.
Yeah, as much as
All the way around. Can't
Yeah.
do that.
No.
Is there, Representative Prue?
So I'm wondering if we start getting too broad, are we getting into freedom of speech and
Exactly.
all that stuff? So anything if we get too broad, then we're
Yeah, it's a fine line, but then it ends up doing the opposite of what its intent is. And we managed to do it with all the other protections classes to define what it means. I think we can do it with this if all of us put our heads together, and we end up agreeing that this is something that we should start doing. Somebody has to stop this, and it's not okay to be. I mean, so far we've been lucky here. Almost had an R&R problem, but that was my fault. But we haven't had any violence. But it could happen at any time, and it's happening everywhere else. We see it, and that's just not. We got to stop that. That's not a way to live. And hopefully, we could come up with some language to do so.
Representative LaSalle's?
Yes, I understand the intent that you have. Let's say you rented an apartment to somebody. The next day, they put up a Confederate flag.
Mm-hmm. Yeah.
Would that be against?
I think that you could handle that in a different way. If, in other words, if you have a policy in your property, you can't hang flags or whatever. I mean, there's no way to anticipate every possible thing.
Yeah.
And so again, is a Confederate flag a political position, or are you a Civil War buff? I mean, I think that should be dealt more with your landlord rules about putting stuff up.
Follow up. How about like Black Lives Matter or Make America Great Again?
That's it. Those are political. Now that's different. If you're going to say, hey, we don't serve people who believe in MAGA here, or we don't serve people who believe in Black Lives Matter here, you've discriminated someone based on their political opinion, in my opinion. And that's what really is what I would like to see us stop doing, because we're seeing it happen now. We're seeing, well, you're one of those protesters, get out, or you work for ICE, get out. I mean, we got to stop.
Representative Muse?
Looking at the second page of your bill and the penalties for politically motivated interference, you know, as I read this, this could catch up everyone from some person, you know, some random person on Facebook or Twitter to the Vice President of the United States.
How
Based
so?
on the
Explain,
Vice
please.
President of the United States, based on some of his statements. So
Maybe.
what I'm really curious about is how
Did I change the, did
how
I
we
change
narrow
the
this
penalty?
down. Huh?
Did I change the penalty? I believe I only just added that to the definition. So the penalty is the existing penalty, isn't it?
Oh, I'm sorry. I'm sorry.
All I did was add that definition to one of the classes that would qualify for discrimination, political affiliation. I didn't change the penalties in whatever Mr.
language in the bill stands the way it is now.
So
Yeah.
this is already in statute?
Yeah,
Part of
yeah.
this is, thank
Okay.
you for clarifying.
Yeah, and whatever Mr. Vance did, I have no control.
But as I read this, it does appear that the Vice President of the United States
Yeah.
could potentially be in trouble if he did something like this in New Hampshire, what he did a few months ago.
And I don't know which you're talking about, but perhaps, you know, if
And
we make a
maybe
law
that's
in New
what
Hampshire.
That's what we need.
Yeah, and
Maybe
if
that's
we
what
make
we
a law in New Hampshire and somebody knows about it and they violate it, I don't care who they are. If we have jurisdiction, I don't think we have jurisdiction over the vice president, but we could
So it sounds
certainly-
like we're going to have some very lively debate during the executive session. I think we might have just had a little bit of one. Are there any further questions? Are you good?
No, I think,
Yeah, sure. Representative Muse?
Just one additional comment. Part of my background, I used to do use cases for web programs and apps and things like that. And one of the things that you do in use cases is you basically kind of design a bunch of situations. And what you do is you kind of run the process based on the point of view of the person who might be coming in based on one of those situations. So I understand saying that there may be some things we're not thinking of, but I really, changing the discrimination statute without trying to think of everything, to me just seems like a lot. Okay.
Is there anybody else here wishing to testify on House Bill 1464 that has not turned in a pink card? Seeing none, I closing the public hearing. Good afternoon. Welcome back. It is 3:30. I am going to open the public hearing for House Bill 1393 and recognize Representative Grota to introduce the legislation. And please correct me if I said your last name wrong. I think I might have.
You said it perfectly well.
Thank you.
Hi,
Whenever
everyone.
you're ready.
Okay, thank you, Madam Chair and members of the committee. My name is Jackie Grota. I represent the towns of Rye and Greenland in Rockingham 24. I'm here to read the testimony from my committee mate, Representative Patrick Long, who is out ill today. The primary purpose of this bill is to prevent federal officials' interference in our elections. The Department of Justice is currently demanding that the Secretary of State illegally turn over the state's voter list, which is clearly protected by law. While this happens to be a Republican administration, it is not a partisan issue. You can easily imagine that a Democratic president or their staff may want to illegally interfere in our elections as well. Right now, anyone who does that would face no meaningful sanctions because judges are far too lenient about allowing frivolous lawsuits. And you can imagine worse attacks than trying to get the voter list, for example, hacking our voting systems. There is no risk that innocent officials making mistakes will be swept up by this law because it retains the existing feature of official oppression that they must knowingly take unlawful action or refuse to take lawful action that is required of them. So this bill allows us to protect our elections from federal interference while protecting many government officials who act in good faith to do their job even if they get it wrong. That's okay. That was the essence of the testimony. So if you'd like, I can send the testimony to your committee clerk and they could disseminate it to the committee. I am unfortunately unable to answer any questions on this bill because I'm just helping out.
Understood. That happens.
Yep, thank you.
Is there any anything that anybody is there any questions that anybody does have? I do understand that she's not really able to answer much, but there might be something. Are we all good? Representative Muse?
Just a general question about whether we have a supremacy clause issue. If these are in fact federal employees, even they may not even be in New Hampshire if they're trying to influence our election, and would we have any jurisdiction to be able to do anything to them? I'm just spitballing there, but it would be nice to have an answer to that question.
I certainly do not know the answer to the question, but my understanding, and you're all welcome to chime in if you believe this to be true as well, is that our Secretary of State is actually actively objecting to this, was my understanding, unless I'm not correct on that. Representative Scheer?
There's not a supremacy clause problem. We can pass laws that say a federal official, anybody, including a federal official, can't interfere with state business. That's our responsibility. As to the jurisdictional question of if they do that from out of state, that's a more complicated question jurisdictionally that would be sorted out in the prosecution. I mean, I don't think on its face there's a problem.
Anybody else? We good? All right. Thank you very much for joining us this afternoon.
Thank you. It's a pleasure.
Is there anybody else here that would like to testify on House Bill 1393 that has not turned in a pink card? Seeing none, I will close the public hearing. And we are going to, okay, Representative Ammon, I did ask him to be here at 3:30. If you guys just give me a quick minute, I'll just text him, let him know we're actually ready for him. He was upstairs in another hearing. And then we'll open up that hearing and move along. So, give me 1 second.
With that, I open the public hearing on House Bill 1423 and invite the sponsor to introduce the bill.
All right, thank you, Mr. Chair. Thank you, members of the committee. I know you've had a long afternoon, so I'm going to keep it short. For the record, my name is Keith Ammon. I represent Hillsborough District 42, and I support this bill. I'm the prime sponsor. So I'll tell you a personal history that led to the idea of this bill. So a few years ago, I put in a contentious bill in the State House. Never happens. And I went home and I got this insane message on my Facebook account. It was threats to rape my wife, threats to cut off my genitals, threats to make my father watch me eat my genitals. It was an insane rant. Yeah. And so, you know, don't want to rehash the history. So the person was arrested and went to court, and the judge let him off with a slap on the wrist. He had to write me an apology letter, which is fine, you know. But when Charlie Kirk got assassinated, I thought about that incident, and I thought maybe our judicial system needs to take these insane threats a little more seriously, because we don't know what could happen. And so I was looking through the statutes, and I found this existing statute of improper influence, which covers this scenario. And I was talking it over with my wife, and she said, well, he threatened me too. And you know, the statute doesn't cover family, right, which is an obvious attack vector. And so that was the impetus of this bill. And so we needed a definition for immediate family member. And, you know, I thought about what would the minimum be that would be reasonable. And that way a judge couldn't let someone off with a slap on the wrist, right? And so that's where the mandatory minimum came up. And that was a fine of not less than $1,000. And it's $1,000 for each individual threatened. And then the idea that any time would be served consecutively, right? So the threat that I got was written, and it wasn't physical, but you could imagine, you know, your car, or, you know, some physical threat that manifests itself in the real world, which would be require a worse penalty than just $1,000. So that's where the consecutively served comes up. So if there's time served, it would have to be stacked and not consecutive.
Does it call for a minimum time period?
No, it does not.
Oh, okay.
Yeah.
It looks like it's got a mandatory minimum 1 year. Is that?
Oh, does it? Yeah. It's been a while since I wrote it. 1 year, that's right.
Okay.
And
We'll
that's
continue.
for.
I don't want to interrupt. Just
Yeah, so that would be for someone that was convicted, right?
Yeah. I would hope.
And so every bill is just a conversation until the governor signs it. So I'm open to tweaking some of the parameters, but I think in the age that we're in, we would want to make sure that people know that if they threaten lawmakers, that, you know, to try to influence our votes, right? That's the key thing. That there is some kind of consequence, that it's not just gonna sit down and write an apology letter and off you go. So that's my testimony. Happy to take questions.
I'll start. So did you think at all about, because in my mind, the person was obviously mentally disturbed, a mandatory psych eval as before we jump right to automatic year in jail? Did you
Is
think
that,
about?
I don't know enough about the process.
Yeah, you can.
know,
It could be a mandatory. We can order. That could be something that could
Okay.
be ordered.
Yeah, I'd
And
be
I
open
just
to
wanted to
that.
know if you'd be open to that as
Sure.
a possible thing.
Right.
because
Whatever,
it-
I mean, you're all in the same situation
Yeah,
potentially that I
yeah.
was, right?
I've been in it.
Yeah, so whatever you think is reasonable, your committee has way more
Sure.
expertise in this area
But
than I do. but-
we always like to make sure that we stay to what you basically the spirit of what you're trying to do.
Okay.
And but we do hesitate to minimum mandatories are a tough sell here and in the House in general.
Yeah.
So a year is a long time when we debate 60 days back and forth, like just to send a message.
Yeah.
So
Okay.
And again, yeah, Representative Harry Gathright.
Sorry again. I have a concern because it does speak to the minimum mandatory is 1 year, but it also says basically for each person.
Yeah.
And
That's a lot.
I mean, if you're
Yeah.
talking 6 people in my household, so you're talking 6 years.
If they
Because
were
it does say
if they were all
each
threatened, right? Like it would be per person threatened. And
If they
I'm
said,
okay.
I'm going to burn your house down, I guess that wouldn't cover the 6 people in the house in 6 years. But,
Could be.
yeah,
I mean, that's a serious threat.
it is indeed. Yeah.
Apology letter might not cover
No,
that.
that's
one.
not. Yeah. I don't think the insurance would like that.
We'll discuss it.
Yeah, sure.
Yeah.
Representative, I can't remember. I need my coffee.
Thank you, Mr. Chair.
Yeah.
I guess like I definitely understand the concerns around this. Like I've dealt with this as well. I've also dealt with a lot of issues around the like free speech part of it and like how prevalent this is, you know what I mean? Like I'm just wondering, yeah, if there's like a better way to strike a balance with like getting the general public to understand that like the kind of language they use against us is not okay, and also knowing that like every time I tweet something there's like 15 people telling me I should go into the garbage disposal. You know what I mean? Like,
I don't think there's one person at this table that hasn't been
Receiving end
Yeah.
of this. So this is an existing statute and it's just tweaks to existing. So I think we need some update to this, right? And when this was written, it was a different time period and political violence wasn't as common as it's becoming, unfortunately. So yeah, that's true.
Yeah, I support the idea behind this. As many people know, I really dislike mandatory minimums, jail sentences, but I think at least a good measure would be a mandatory minimum fine, which is included in here. But I think a mandatory minimum fine, while not my favorite thing in the world, does send a message, and I would. I think I might be supportive of that.
I think I think this is a issue, to your point, that is serious enough that we all deal with. That we'll probably. I was thinking subcommittee, but maybe we'll just do a committee of the whole, and we'll get together one day and just hash this out between all of us and see what we can come up with. Because fines are great, but you can't get blood from a stone, and sometimes people. So maybe a minimum, but if I'm thinking, 30, 60 days, not years and long, but we can discuss that when we get together. Yeah. Any other questions for the representative? Yeah, sure.
So recognizing we do have this statute, we also have another statute that covers criminal threatening. And it sounds like what your family went through is a kind of a textbook example of criminal threatening. And so what the statute says, criminal threatening, there are a bunch of different things that constitute it. But one of the things is the person threatens to commit any crime against the property of another with the purpose to coerce or terrorize the person. And the next one is the person threatens to commit any crime against the person with another with a purpose to terrorize that person. So it sounds like, we may already be covered here. I'm just curious what you think of that.
So I told you my experience and the fact that it came down to the penalty was an apology letter, which is what you do in kindergarten. It wasn't taken seriously.
No, but what crime was your perpetrator charged with?
Yeah.
I don't know that for a fact. I should.
Yeah,
look that
can
up.
you find out?
I can find out.
Yeah, because if they were charged with criminal, in other words,
Yeah.
if I call and say I'm going to do X, Y, and Z to your wife, that's a crime already because I've threatened to
Right.
commit a crime.
So undue influence, this statute
Yeah,
is
it's just for
specifically
us.
about trying to terrorize us for the purpose of changing our vote or withdrawing a bill.
And that's what your
And that's
threats
what
were
I'm
about.
trying to, and that's what my experience was about. That's
Yeah.
why I chose this chapter.
I think
but
every one of us, though,
maybe-
actually, our things are about stuff we've done politically. So
Right.
you're correct. That is a distinction.
It would be
from-
similar to like threatening a judge because you didn't like the way the judge ruled on a case, right? Like that,
Yeah.
or threaten them ahead of time to try to influence how they rule on a case. It's, it's a special circumstance when you're in the government, I
It
think.
is. And I think we also most of us agree, we're not special.
Right.
But we don't deserve any privileges. But we do sacrifice a lot for what we do, and we shouldn't have to. And additionally to the insult of only being paid $100, have to put up with stuff like that.
And if I could just
go
make
ahead.
one more statement.
There's nobody here. So
There's
I'll put it wide
another
open.
aspect to this that we could consider is if the climate that we're in, if it continues or even accelerates, right? It's going to discourage good people from running for office.
You're right.
Right. And that's, that would undermine the quality of our democracy if people are afraid to run for public office because of all the threats, right? So just keep that in mind if you're,
You're right.
you know,
That transcends political parties.
Parties,
It's
right.
both of us. Go ahead.
Just, and we can, obviously, we're going to discuss this further, but as you describe the threats, I don't need the details of this.
I didn't even go into all of it. I'm just giving you. a
Yeah,
taste
no,
of it,
I understand
Thanks
that.
for the G rating.
I think, speaking personally, a lot of the threats that I receive are, and this is what should happen to you because you already did this, and the language of this does not cover that. All this covers is, you better do this in the future, or this is going to happen.
That's a good point.
And I think the way, lines 4 through 6 are written doesn't cover threats that I'm going to do this to you because you've already done this. So just, it's something.
So that's
something for
existing
discussion.
law there. So just so you realize. It's a good point that the representative made, but it's existing law now. So you'd have to tweak. It's only what's in bold is new. So of course, yeah. And sorry, I recognize there's a free speech issue here, right? There's a fine line between chilling speech and protecting, the legislative process. So. All right. Thank you so much.
Thank you, Representative Henry Guyson, Hillsborough 29th District, Goffstown. So, federal law 18 United States Code 610 through 618 make this a federal offense: coercion of, threatening of, intimidation of an elected official for the purpose of changing their vote, retracting a bill, or any politically motivated purpose. I would offer that language for some of the concerns that were brought up about this being forward tense or past tense. I mentioned during the doxing bill what had happened with my family, threatening to board it up and burn it down and punch me in my blank face because of a bill that I voted on, that I was not a sponsor, didn't push through committee. It was a bill that, just like all of you have voted on bills that you don't necessarily know where they came from, but you make your educated decision. You have to push the yes or no button because you're in your chair. I voted on a bill, and that's what caused that. Now, each of us here, and everybody down to the town alderman, is in their position because at least 50% of their constituent basis has thought that they should be the voice for the people. When you threaten the voice of the people, you silence the people. When you coerce the vote of the representation, you silence the people that voted for them. And that's very real here. It's very real to be intimidated. Now, I mentioned 18 U.S. Code 610 for reasons. I could have and probably should have called my local federal law enforcement agent and had an investigation on that. There's right now a public inherent distrust from some people in federal law enforcement agencies. So if we as a state do not create a state law that can be enforced by our own police, I would ask the committee, are we not inviting further federal law enforcement agencies to come investigate? And also, do you think that a federal law enforcement agency is going to care to investigate if somebody threatens the alderman or the selectman of your local township, even though that is covered under this federal law?
Yeah, it's a question of, actually, it's the U.S. Attorney's decision, and I don't care whose administration it is, that there's not enough of them to handle those type of cases.
Yes, sir, Mr. Chair. And so, Mr. Chair, you and I were talking earlier about, the prevalence of political violence in the community, and I do believe that this transcends all political parties. The execution of the honorable speaker in, I think it was Minnesota, correct? Were there threats made before that, and could that execution have been ended if there was reasonable enforcement of criminal threatening in advance of that? None of us can ever know. So I do believe that it's incumbent on this body to create a methodology for our law enforcement to get in front of this. Free speech does not include criminal threatening. Somebody says, I hope that you die. That's much different than somebody telling an elected representative, I have a plan to harm you. Those are very different things. One is protected under free speech. I can say I don't like you and I hope something bad happens to you. I cannot say I have a plan to cut the brakes on your car so that you go off the road and die. One of those is a viable criminal threat, and the other one is covered under free speech. It's in poor taste. It's despicable, but it's covered. So, and I would caution about the psychological evaluation, simply because those methods are already there if somebody is criminally unfit to stand trial. And also, somebody's psychological state of being does not negate the validity of a threat to a victim. So I would be very careful on how you phrase that. I believe that covers all of my notes, so pending any questions, I will thank you for your time.
Thank you, and we appreciate the input. On the psychological is a good point. There are existing statutes for that. I would think more along the lines of if there was a clear evidence that the person, in other words, if they didn't have enough evidence to, beyond a reasonable doubt, put someone in jail, but there was enough evidence this person needs some medical help, mental health help, that type of situation. But we'll hash all that out. We'll figure it. Thank you, though, very much. Anyone else wishing to testify on this bill? Seeing none, I hereby close the public hearing. And I will see you guys tomorrow. Actually, before everyone leaves, shut off your. Tomorrow's going to be contentious.
Your mic.
What is tomorrow?